Hello, 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 hello. Hello, hello, hello. Hello, hello. Hello, hello. Ayun na. Hello, 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 hello. Hello, hello, hello. Hello, 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 hello.
লোকালে এলইডিখন অফ কৰি থবা বেটাৰী কম আৰু ব্ৰেকফাষ্ট
কেবুলৰ সেইটো চাইডে গাঁঠি দিছা?
ডাবল ডাবল আটে
như vậy à? Như vậy. Như vậy.
A very good morning. On behalf of Intellectual Property Rights team of Bodoland International Knowledge Fest, I welcome you all today to the very first session of Intellectual Property Right, which is Invited Talk. So to begin with, I would like to request our guests to please take their seats on the dais. I would like to request Dr. Manoj Deka to please escort them to the dais. Thank you so much to our invited guest on the dais. We take this opportunity to welcome our guest, invited speaker, Professor Ganesh Hingmire, Chairman, Great Mission Group Consultancy. We'd like to felicitate him with the traditional Aranai, and I would like to request our students to please come up and felicitate him with an Aranai and some gifts as token of love from us. Professor Ganesh Hingmire is a renowned intellectual property enthusiast and a winner of 2 consecutive National Intellectual Property Awards in 2015 and 16, given by the Ministry of Commerce, Government of India. He has constantly supported various industries for their intellectual property right registration and commercialization since 2002. He is a visiting faculty to most prestigious academic institutions in India and delivered more than 1,000 sessions in different states, including IITs and national law schools. He is the founder of Great Mission Group Consultancy, which is dedicated towards the promotion and protection of intellectual property rights in the country. He is also the founder and director of GMGC IPR Services Private Limited, a startup recognized by the Government of India under the Startup India scheme launched in 2016. Indian Institute of Technology, Kharagpur, invited him to chair the session and inaugurate the Patents and Geographical Indication Drive program in 2016. His organization has memorandum of understandings signed with many renowned colleges, institutions, and universities in Maharashtra for the academic promotion of IPRs. We are truly blessed to have you amongst us, sir, and thank you. Next, I would like to introduce Professor Kerekoppa Ramesha, Center Head, NDRI Bangalore. I would like to request our students to please felicitate him with an Aranai and some gifts from us. Professor Kerekoppa Ramesha is the principal scientist of animal genetics and breeding, and he is also acting as the director of ICR NDRI Foundation. He has worked in the station, Southern Regional Station of ICAR NDRI, Bangalore, since 2016 to 2023. As head of the station, he managed the station and involved with managing, teaching, research, and extension extension activities. Because of his efforts, he was successful to register Malnad Gidda dwarf cattle of Karnataka as a breed in 2012, and also recently, in 2021, he was able to register Dharwadi buffaloes as a recognized breed of buffalo. He has developed technologies and has 2 patents and filed 5 more patent applications. He has published around 130 research articles in peer-reviewed journals, besides scientific and technical publications, including reviews and status papers. He has 15 books and book chapters to his credit. He has been awarded with many awards. To name a few, Fakhruddin Ali Ahmed Award by ICAR New Delhi, Dr. G.B. Singh Memorial Award 1993 of the Indian Society for Study of Animal Reproduction, Visiting Fellow of JNCASR Bangalore, Indian Indira Gandhi Sadbhavana Gold Medal Award 2013, J.C. Bose Award Best Veterinarian Award 2011 to 13 by KVA, Best Zoologist Award 2013, and Fellow of Association for the Advancement of Biodiversity Science and National Academy of Dairy Sciences. We welcome him and we are so happy to have him amongst us. Now we would like to request our students to felicitate Dr. Sanjeev Paul, scientist from Indian Institute of Chemical Technology, Hyderabad. Dr. Sanjeev Paul is serving as a scientist in CSIR, Indian Institute of Chemical Technology, Hyderabad, focusing in the domain of IPR management, technology transfer, patent licensing, MOU validation, patent drafting and handling, prosecution matters, patent valuation, technology promotion, national biodiversity matters, and related aspects of policy matters. He was the former examiner of patents and designs in Indian Patent Office under the Ministry of Commerce and Industry, Government of India. He was also involved in RMIT activities and assigning IPCs to the patent applications. As patent examiner, Dr. Paul examined more than 500 new patent applications and nearing same number of amended patent applications. For his capabilities and performance, he received several appreciation letters from CGPDTM, Ministry of Commerce and Industry, Government of India. Dr. Paul is also interested in various interdisciplinary R&D activities. His area of interest includes environmental safety and biodegradable packaging, edible films and coatings, nanofood biotechnology for environmental and nutritional safety and security, microbial processing of food, bioprocess technology, fermentation, food biotechnology, food product development, industrialization of indigenous food products, IPR management, and related issues. We welcome him to our invited talk session, and we thank him for being amongst us. Next, we would like to request our students to felicitate Mr. Aditya Mittal. He is a patent associate of Alice Dower and Co., Delhi. Alice Dower and Co. is India's oldest, largest, and most trusted intellectual property prosecution and litigation firm since 1932. It has been serving as a trusted IP partner of global large and mid-sized companies and foreign IP law firms. Alice Dower has been widely acknowledged by Government of India and various notable and renowned IP forums in addressing multidisciplinary IP challenges of all types of protection, including Indian courts at all levels and different Indian IP offices. Alice Dower is known for the contribution in areas of IP policy making and active participation in drafting legislation in various areas of IPR. Mr. Aditya Mittal is an IP attorney with demonstrated experience in patent prosecution, patent drafting, pre and post grant oppositions, and litigation. He is actively involved in planning and strategizing in reaching out to potential target customer segments across the globe for Alice Dower and Co. So we welcome him, and we are happy to have him amongst us, and we look forward to this session of invited talk because we have such persons who have great expertise in the area of intellectual property rights, and we have hope that from this invited talk session we are going to learn a lot about IP. So with this, the felicitation and introduction round is over. Now we'll proceed to the presentations. Because the presentation will be requiring the use of the screen, we would like to request our guests to please take their seats on the front row of the pandal. Thank you so much to our guests and to all the participants who are present here today. Intellectual property rights are the rights given to persons over the creations of their minds. They usually give the creator an exclusive right over the use of his or her creations for a certain period of time. It is well established by now that the contribution of IP is immense in the modern economy. There has been a prominent predominance of knowledge and intellectual capital in wealth creation from countries to individuals in a global economy. Also, we can see the growing emphasis on innovation and entrepreneurship has resulted in the synthesis of new technical ideas by students, researchers, and faculty in academic institutions. Therefore, it is very important to protect these ideas. The concept of intellectual property rights widely ranges from stages of identification to utilization, documentation, and management of the same. Awareness of intellectual property rights not only assumes critical importance, but also enhances motivation to develop and disseminate scientific and technological innovations. With this in mind, let us proceed towards our first session of invited talk, which shall make us understand and address emerging problems and issues in regard to intellectual property rights, and also create awareness and facilitate a stimulating environment for the development and exchange of ideas in the management of intellectual property rights. So, we would like to begin our invited talk by first inviting our resource person, Professor Ganesh Himbini, Chairman of Great Mission Group Consultancy, to present his deliberation.
Respected dignitaries, students, participants, organizing, I must thanks to BTR government, my friend Lingji, for an opportunity to share thought on cultural entrepreneurships, particularly through intellectual property right, what we can say, invaluable treasures of incredible India. And let me connect you all first to the intellectual property right in 2 minutes, and then I'll jump to the geographical indication where I would like to share a thought on cultural entrepreneurships through geographical indication. So you all are here to discuss the intellectual property right. So we all, I think, little bit familiar with the concept called as an intellectual property right. The property which is created by intellect is intellectual property right. That's the concept. And there are two aspects which always attach with the phenomena of property, what we can say, possession and ownership. So when I say this, Panther Leaves belongs to University of Bodoland. This is a property of Bodoland University. But if I say the book which right now published by the Bodoland University, that may be a compilation of all the presentation, is another intellectual property of Bodoland. That is what we can say. You can take that property to anywhere. That's why I'm taking it to the Pune. Sir will take it to the Bangalore. Third person will take it to the Hyderabad. So your property is shifting to one place to another place. That is what intellectual property. However, you cannot take this place to the Pune or to Hyderabad to Bangalore. So that's how the importance of intellectual property you can easily understand is a most important property. The value is very huge, and our what we can say, our day start with someone's intellectual property and our day ends someone's intellectual property, but we are not aware of the fact that we are all attached with intellectual property, right? We are paying huge amount. I always quote an example of Parker pen. How much you pay for a Parker pen? Maybe a 500 rupees. If you remove the name Parker from that pen, you will not even pay for 10 rupees. So that's the importance of intellectual property. I conclude in 2 minutes. Now my role here and my paper is with respect to the cultural entrepreneurships. So here I would like to utilize my experience, exposure have had and happen on geographical indication, where we have worked for the 6 states and different geographical indications. Geographical indication is one of the form of intellectual property right. Ma'am mentioned about the inventions, innovation, patent. Sir already filed the patents from Bangalore, particularly from institutes. That is one form. Patent is quite aware of, quite, we all are aware of the concept called as a patent. When there is an invention, there is a patent, something like that. You all are also available concept called as a trademark. That's simple. Maybe Mercedes-Benz or your Colgate or your Pepsodent, etc. Those are names, those are trademark. You and me cannot use that. That's the protections available for the intellectual property right. We all are available also a concept called as a copyright. That's the book I said compilation. But none of you are majorly aware of the concept called geographical indication. The gift which we have received is cultural symbol, Arnai, Dokona. So those are your culture and now became a part of gift culture. And that's how it has been shifted from culture to gift culture. Gift cultures, that's some kind of an entrepreneurship where you are providing a platform to local indigenous people, because you might have purchased maybe a 5,000 arnais, and that's a kind of an ultimately a source for them. And that's how we can lead towards intellectual property to cultural entrepreneurship through intellectual property called geographical indication. And that's my concern for today's paper presentation. Next, please. So here is the scenario. Last year, China. I say geographical indication is a form of intellectual property right, and I'm trying to connect you all with this Arnai, Dokona, market, purchase, entrepreneurships, and then ultimately prosperity. Because trade is required for the prosperity. And trade will generate the employment, and then employment will take you to the, again, not only the sustainability, but ultimately the prosperity. So here, China, they have filed more than 9,000 GI. Next, please. European Union, they have more than 60,000 GIs. And further, next. Next, please. Here is the ultimate message to all of you, how cultural entrepreneurships through GI can be in cash. Here, basically, I gave you an example of Arnai that Bodoland University might have purchased those Arnais from the local people and now available as a gift culture. That is one aspect which I told. However, let me tell you in a global perspective on the cultural entrepreneurships developed there in European Union. This is an example of their success stories on cultural entrepreneurships. Out of, say, 60,000 GI they have registered, more than 51% are for wine and spirits. Some of you may aware of some name like a champagne and Scotch whiskey. It's their culture, basically. Champagne is a place from the France, and that's their culture is, that heritage drink they call it. However, that is an alcoholic beverages. So that is their culture. Scotch whiskey is from the Scotland. It's their culture, and they promoted their culture through GI. And the Scotch whiskey and the champagne is available almost all part of the world. And there you can see how they develop, how they utilize their culture as an entrepreneurship. And you can see the example. This is a figure from during particularly pandemic period. They have European Union particularly officially declared this figure. They have sale value for their GI is almost 75 billion euros, and out of that, particularly 15 billion euros are from exporting of the GI product. So that's how their culture reached to the globally, and they also receive the foreign exchange. Through that, you can see they're not only sustaining but they are developing. So that's the cultural entrepreneurship through the GI is a success model at European Union. And the same same you can say trend adopted by the China, and they are also now registered the highest GI. But unfortunately, in India, we have very less number of GI, and hence cultural entrepreneurship is very less, and that's how we want to promote. And hence the intention behind this paper is to take this subject to the masses through this international conference. Next, please. So this is what I mentioned: 51% from wine and spirit, and 40 plus from their agriculture. So India, also known as particularly agrarian economy, or what we can say sometimes, agriculture is the backbone of Indian economy. And I can see here uh, many dignitaries came from the different part of India, and they can agree with me, particularly on this part. India's real culture is agriculture. And hence, we can say we have to protect it, we have to promote it, we have to exploit it, we have to enterprise it. That's what had happened there in Europe. Next, please. See, this is from our side, from Borderlands. We work for 75 GIs. Amongst them, there are opportunities for many products from this place, and I take this opportunity to take this message to all of you. Some of you might have heard about the Jamgran, Chang, might have heard about the Chang, might not have heard about the Changs, but Javishi, Jagran, Magra, Jalbidwi, and these are another two products from different states I have worked, and an opportunity to all of us. My ultimate submission over here: if champagne and Scotch whiskey is available throughout the world, why not my Jagran or Mawa or Chang should be available to all over the globe? And that's the concern. Rather, I compared this Marlborough Jobbidby with champagne and Scotch whiskey, where we found more opportunities are available for our products. If they receive the GI, they will do the same or rather better than the champagne and Scotch whiskey. If you compare with champagne and Scotch whiskey, those are registered GI from different part of world. You compare, they are mainly focusing on the alcohol. However, ours are nutritional as well as medicinally sound products available from local level. And that's how the local entrepreneurship, if we register it, if we take it to the next level of trading, if we take it to the global, and there you can see the not only local people will be benefited, but the entire nation will be benefited, because foreign exchange will be available to our country. And then you can see what happened to the Europe can be happen to the India through this intellectual property called GI, and through that, again I'm repeatedly saying, a cultural entrepreneurship. So here, the most important part we would like to submit is not only you are protecting an intellectual property from your place, but you are protecting your culture, you are protecting your heritage, and that is what had happened with the penny from the Goa. Goa penny protected as a GI, and now they declared the Goa penny as a heritage thing. The similar model, what we can replicate in our Bodoland, and then Bodoland intellectual property will be available throughout world, and a good amount of revenue will be generated through this intellectual property right. Next, see, go back to the previous slide, please. Maua, when I work for the Maua, I must tell you, medicinal important, which I have covered in my paper as well. Maua is basically not only used as a heritage drink, but also used as a medicinal ingredient when the woman gives birth to the baby. That time they are using Maua as a sanitizer naturally since generation. Next, please. See, unfortunately, it's not clear, but our ancestors, this is actually from the Charak Samhita. The picture is not clear. Charak Samhita, you might have heard about the Charaka written many sculptures and this. So here, it's particularly mentioned that but nature, alcohol by nature is a food. When used in appropriately, is for getting a disease. There is a limitation. So of course, if you cross that limit, then that's not good for you. So here, and when you use appropriately, it's like a nectar. That's how it is mentioned in the Charik Chanila. So alcoholic culture is not an alcoholic culture. That's a beverages as per the need. When I said about the soor, I registered the soor from the Uttarakhand, and then you'll find more than 50 ingredient, that's herbs are used to prepare this soor. So to stay in the adverse situation, they have developed this culture, and I think the most of the basis of the many culture are need that as per the indigenous community develop that, and that should be converted now into the cultural entrepreneurship is an ultimate aim behind this presentation. Next. So this is from the Ayurveda. Next, this is about the soor. That what I mentioned that can be traded and can be replicated to the champagne, to the Scotch whiskey, and to many other products like even tequila from Mexico. Those are registered GIs, and because of the registration, they have created an entrepreneurship. And the similar model we would like to develop here in India and can be started from the borderland. Next, please. Jagran already. This is a rice beer, and it's a great demand. So I request the youngsters they can join the hand to the government for a good initiative on such kind of GI registration and entrepreneurships thereafter. Please next. Chunk. This is work from the Ladakh. You will find again very useful cultural heritage products, and it's in final stage of registration. Next, please. Maibra, you know that's rice from Borderland, and it's a rice beer, great demand, and can be converted into the cultural entrepreneurship properly if it is tapped. We have a lot of plans, and that will be incorporated as soon as possible once the GI registration is been granted. Next, please. Maua, I have already mentioned. See, our indigenous people are very close to nature. They respect the nature. They also treat various natural sources as their god. So a similar thing happened to the maua, where they treat the maua tree as a kalpataru. It's God gifted tree, and every part of this tree has been used. So it may be a flower, it may be your branches of the tree or anything. So that's how now we need to take this product, this intellectual property to the masses, and the whole world should be benefited from their traditional knowledge is the ultimate concept behind the internet. Next, please. So this is how I have mentioned about the Goa Penny. It's already happened to the other player, part of India. Then why not be there in here in Northeast or somewhere else? So they have this Penny Policy 2021, and through that they wanted to promote this product globally, and they began. Next. This is a comparison. I made it with Soon. What is the price? 50. What is the price for tequila and Scotch whiskey? 4,000. So how to different? 200%. So we can take it to that level. And there we can create a cultural entrepreneurships. What they created, that can be replicated. I am repeatedly saying here in our place. Next place. We have also compared. Next, go back to the place. We have also compared that raw material. So where we can have an upper hand on our culture. So where we are using the many good raw material and can be utilized for better human health in futures. Next, please. Next. So this is our culture. Then apart from the food culture, we also have music, where you get the peace, where you get happiness. Those things are also applicable. And nowadays you might have heard in Kerala, there is a medical tourism. In Maharashtra, we have agro-tourism. And a similar type of things, we can also create a musical tourism through this GI. And that's an available of cultural entrepreneurships, where you can invite people for their peace of mind and happiness and all. That can be possible. Next. So these are the various instruments which we work. Sherja, and again you will find it's really very giving you a lot of peace, happiness, satisfaction. Next please. So always music is another. Shifan, this is also we work from place from the Bodoland. Next please. Fortunately, we have Linky who helped us a lot. Rather, he who taken initiative, and I must say thanks to him and his father for an opportunity and taking the Bodoland to the next level. And particularly working for the indigenous community, and really an intercultural internship will happen here in Bodoland very soon. Calm is another where you will find mythological stories are so interesting. When you play the calm, there is an intention that Bole Baba should get the message from you, and people should come together while playing the calm. So these are the some good example which we have covered, and it's an instrument, and where you have a lot of interesting information and stories to cover, and can attract the tourism also. Next. Jotha, similar line, another musical instrument. Next. Congo, next. That's another culture, what we say. You gifted, I begin with that. Arnai, your Dokona, and all. These are again cultural symbol. And that cultural symbol should be converted into the cultural entrepreneurship. But those cultural symbols can only be recognized through intellectual property right as a geographical indication. And geographical indication act we enacted in India because of the WTO, World Trade Organization. So that's the opportunity globally available to all of us. We can take it to the other places. I had been to the many countries, and when I was there in Geneva, I found fake pashmina was available with $10, and that's how the duplicate products unfortunately reach the market, and original products are defeated because of the fake products available in the market. So that should not be happen to our products. Hence, those products need to be protected and then promoted. We did it for various GIs, and Paithani. A success story is there at our end on Paithani Sari when I registered in 2009. A cultural entrepreneurship happened properly there in Paithan from Aurangabad districts of Maharashtra. Next, please. So this is a success story which I have covered. This is actually fabric. This is also known as a Mahavastra. So I say, not you are protecting GI means not protecting any intellectual property, but you are protecting your culture, you are protecting your heritage. Here, how we protected our culture, it was referred in the Mahabharata as a Mahavastra. So it's kind of a tribute to our forefathers. Sometimes we say GI is our forefathers' patent. They have identified certain product unique and entitled to be produced in that particular region. So maybe a Darjeeling tea or maybe a Mahabaleshwar strawberry, like your Dokona or Arai. So here, Paithani is from Pathan during the Shalivahana period that has been recorded, and Mahavastra is the record. So you are protected your culture, you are protected your heritage, and then nowadays people are getting an opportunity. I remember when I registered this in 2009, even they were not having electricity at their handlooms, but nowadays they are not only receiving the national awards but getting an order from government for the various projects for their Paithani. And now, not only they have restricted themselves to the Paithani sari, but they begin with the Paithani jacket, Paithani tie, and other fabric products. So cultural entrepreneurship has been created. And recently, 1 month ago, there was a movie released in Maharashtra in Marathi called Paithani Sari. So that's how the brand has been created, and it's been promoted in a cultural way, in an entrepreneurial way. Next, please. So this is a head here which we have registered in 2007. Puneri Pagdi, a symbol of intellect. You won't find any single photo of Lokmanya Tilakji without Puneri Pagdi. You must be knowing the Lokmanya Tilakji. So that's next please. So here we requested university, and that's where I'm going to connect University of Bodoland to here. We registered this in 2007, and we requested university to replace the convocation hood with the Puneri Pagdi. And recently in 2020, they replace convocation food with the Puneri Pagdi. So there will be a 5 lakh Pagdi demand for Puneri Pagdi. So who will prepare? Those are basically women entrepreneurs. They are commonly known as a Pagadban community. So they will get an opportunity and employment has been created. So just imagine that you need not to go to the technology every time to create new business, but the existing cultural symbol is also available for your business purpose, and entrepreneurship can be created. And this is what had happened at my place. And the various community, maybe Kosti, what I said, Pagalban, and mainly the woman empowerment can be happen, and it's happened at my place. That's the Pune Republic which we have registered. And you will feel pride when you become a graduate and you're wearing a Pune Republic. That's what the another advantage you have. It's a cultural entrepreneurship. Next, please. ED silk, we have already discussed, that's an indie silk, this is from your place, and it's a very well-known product, and cultural entrepreneurship is definitely will happen because this is also known as an Ahimsa silk, silk won't die. So that's how you can catch the market. You have a USP, unique selling point, and that through that you can grab the global market for this product, and it's available. There are many people who are now vegan and do not want to kill the animals, and here is an opportunity for you to tap such a good crowd of, and then you can further create a cultural education. Next, please. I say, you might have purchased 5,000 or more than that to give this as a culture. And even Honorable Prime Minister is gifting the Arnai to other dignitaries. So here you can see, gift culture will also create a cultural entrepreneurship, and that's an opportunity to our local here. Make sure that duplicacy should be restricted. Some people are always eagerly waiting to copy, and then if you have a right, you can restrict them. If you don't have a right, you will not get any opportunity to restrict them. So that's another advantage you will find in intellectual property right for the cultural entrepreneurship. Darjeeling fought 16 cases globally because they had GI. And that's the advantage you can say. Once you have a GI, you can restrict others, and you can have the exclusive monopoly right with you and your people only. And that's the cultural entrepreneurship. Monopoly is required in today's world. Exclusivity is required in today's competitive world. And that can be available through this GI, through this intellectual property right. Next, please. Dokona, next, please. Same from this. Next, please. Next, very quick. Traditional days. So I work for the Bosri Dal, and all these are different products. Renuka Mata, that's from Nanded. This is a tambul. When I was roaming and around there, I found people are calling pan as a tambul. But tambul is basically a pan, and particularly that is on a Shakti Pit in Nanded. We have applied a final stage of registration. 13 products. In Sanskrit, we found the reference of Trayodashi Vida. That's a Vida. We will find 13 small products. So you imagine 13 agricultural products got an opportunity through this product. So your cultural entrepreneurship will not restrict it to yourself, but there are many marginal farmers will be benefited through your cultural entrepreneurship. So through that, that's an opportunity for the Renuka Mata, Gwakawaki, Ranya Roti. There are many indigenous people, they don't use some kind of cylinder, gas, or other instrument. They use some traditional way of cooking as a roti. You might have heard about the Rumali roti. So Ranya roti belongs to the Mahar community there in Yavatmal and Nagpur districts, and we have had an opportunity to work for them. And exclusively, women are making this roti. You will find this roti is very tasty and long-lasting as well. So that's how cultural entrepreneurship is providing the platform for the many women's empowerment. Next, please. So, Onla, that you know better than me, cultural entrepreneurship. So, our food culture is important. Next, please. Borsari Dal. This is another from a very small village, and the name itself is derived from two adjacent villages, Bor and Sari. And there's a specialty. If you cook this dal outside that place, you won't get that taste. So that's how the geographical indication is attached. So water is available exclusively in a precise manner for this dal, and that's a tasty food. And you will have to go to them. It's indirectly again created what you can say tourism to those village, and then economy, particularly rural economy, will be very boosted through this entrepreneurship. Next, please. Next. Next, I think पीछे जा रहे हैं. Napalm is fermented fish. We have already worked. That's an opportunity. The whole world is in demand of various vitamins, and you will get these vitamins from this. That's how you can create a cultural entrepreneurship through this GI. Next. So this is how we work. Fortunately, in 6 states, protecting the intellectual property border. I must conclude my presentation over here. Your intellectual property in the form of GI is not only protecting your creation, but it's protecting the India's assets. That is very important. You have to remember. Instead of taking it by someone else, you can protect it at your end and then promote it in a better fashion as a cultural entrepreneurship. So this is how we work. Next, please. So these are different communities or different states, particularly we have had an opportunity to work. Next, please. This is how we protect. So if you wanted to contribute for your motherland, need not to be a soldier always, but you can be a soldier at your aim with your subject, with your topic, with your domain, and you can protect our nation's boundary with that. And that's what had an opportunity. We protected the intellectual border of India through the geographical indication. We propose cultural entrepreneurship for all these GIs in the length. Next, please. So this is how I have had an opportunity to work. Similar thing you can do at your own place. You can prepare your GI map, your state-wise GI map, your district-wise GI map, and that's the first step towards the cultural entrepreneurship. You identify the product, you work for the product, you collected the evidence, you search for the support, you have the registration, and the next small thing can be prepared, and one of them is a first step to prepare a GI map where you don't need to spend huge money, and that is what we have. We did it in Maharashtra, and now government of Maharashtra started procuring GI product with premium price. So 11 products are now second consecutive year procured by the government of Maharashtra. So premium price is now available for your GI. Next, please. With this, I am thankful to the organizer for an opportunity. Let me conclude very precisely. We all know intellectual property, patent, copyright, trademark, but let us focus on GI, which is a cultural symbol, which is also the heritage symbol, and through that we can create an entrepreneurship, and that will be a cultural entrepreneurship for incredible India, invaluable treasure called geographical indication. Thank you very much.
Thank you so much, sir, for presenting an elaborate expression on geographical indications and cultural entrepreneurship, and especially emphasizing on the significance of cultural entrepreneurship, especially when Bodoland or BTR is rich in so much of cultural products, indigenous knowledge, and it is very much essential. And here I would like to also add that sir has been taking the initiative to register 21 number of GIs from BTR, and we are waiting eagerly for that to happen. So a big round of applause for Ganesh Ingvire sir. So it is now open for interaction. Any question can be addressed by sir. If there is any query from anybody here, then can.
Morning, sir. Actually, what is the procedure to have work with this actually? So, what is the procedure to work with this? Yeah, process to work with this GI that you are actually explaining.
Thanks for this technical question. GI is a legal right, and process is mentioned in the GI registry. Process start with point number 1, identifying the unique product. So when I say musical instrument, it's a general. In specific, Sherja. Then Sherja, what is the specialty of Sherja? So identify the product with the help of local people and through internet. So there are two ways. One is secondary data collection, and second is a primary data. You talk to the people and get the information. So that way you identify product and then you start deep study, particularly collecting the evidences in support of the uniqueness. So when you say particularly chunk, so you'll have to collect the information that what are the ingredients required for this chunk, from where they source. That is the second step. Then you see third step that in support of those process and unique raw material, what is the specialty of that? And that is the third step. And once you have sufficient data available, then you shift to the drafting of an application. You submit an application to the GI registry. GI registry is working under the Ministry of Commerce and Industry. They will record your application. They will issue, now it's a technical part. They will issue the FCR, formality check report. You'll have to reply to that. Once you reply to the formality check report, then they will arrange the consultative group meeting. Consultative group meeting will verify your product and your community, and they will grant the GI certificate. So it starts with the detailed search, it ends with the certification, which will be valid for 10 years, and you have to renew thereafter. That's it.
I think that also calls for documentation of the traditional knowledges.
Yeah.
Right, sir?
Yeah, basically, those are two different circles: traditional knowledge and geographical indication. Traditional knowledge may be available at individual level. Say certain kind of diseases, maybe piles or something like that. So individually they may have certain, tradition of curing such kind of disease. So hobbies is one of them. But that may be called as a traditional knowledge. However, GI's community is intellectual property. GI is area specific intellectual property right. So when I say it belongs to the Bodoland, all districts belongs to that. So different people of that particular community are involved and they should be benefited. So GI is a big circle and traditional knowledge is a circle within the circle, you can say. So it may be at individual level, but this is a community level. So all community will be benefited through the GI.
Sir, just quickly, I just wanted to know clear two of my confusions. Sir, one is that GI is a community's right or a geographical right. For example, if we are applying for GI in Bodoland, for the Bodo, which is specific to Bodo community, and if a Bodo person is living in Maharashtra per se, and if that person also can exercise the GI's right. Secondly, sir, how do we manage to handle with GI tags when things are blurry? Like there are confusions between West Bengal and Odisha for Rasgulla per se. Then such kind of matters.
Let me answer the second question first, which is in the interest of India. That's why I'm asking. Why we should fight for ourselves? The Odisha Rasgulla. If I request you, you all can see my big presentation come lecture published by IIT Kharagpur on this issue. I was invited there as a chair. I mentioned clearly those rasgullas are different in color, in taste, their identity are different. Then why should we restrict and fight with the state? Let have the more. What I said, I think whether you were there or not, China registered more than 9,000 GIs. European Union, they have registered more than 60,000 GI. Where we have hardly 415. And in agriculture, we have hardly 120. Where we are wasting our time in fighting with other last 21 years. So better to get more. In West Bengal, they have 3 mangoes registered in 40 kilometers. I can give you the number in 111, 112, and 113. Lakshman Bhog is one of them. So you should have more GIs. That is first. In every 30 kilometers onwards, you will find the new products. So get it recorded first. Tomorrow, next generation may not have the access. I can tell you the story in short. When I worked for this chapati making patent for the Singapore company, we found in 1942, the chapati making patent was granted to one Gora, one Britishers. So you today can you claim on that कि मेरी दादी मेरी नानी चपाती पहले से बनाती नहीं आपके नेक्स्ट जनरेशन बोलेगा दुग्गलाचार्य कह रहा है कि चपाती मेकिंग का पेटेंट अंग्रेजों ने लिया मतलब अंग्रेजों ने आपको सिखाया. So record is most important things and that should be happened with the GI registration. Now coming to your first question, if someone shifted from that place to other place, I'll tell you, if we continue with that originality of the production, then with the help of local organization, which is a registered proprietor as per the GI Act is concerned, need to submit an affidavit. There won't be change in the quality. Take an example of Kolhapuri chappal. Take an example of Paitani sari. I registered Paitani sari. Paitani sari is really originated from Paitan of Aurangabad districts. However, 2000 weavers migrated from Aurangabad to Nashik district in Yaula due to the flood. But they continue with the same quality. They continue with the same tradition. They continue with the same process. And they submitted affidavit. But due to the need, they migrated. And in that case, they are entitled. But in the other case, just wanted to take an advantage if someone migrated from borderline to the Bangalore and started organizing power loop, then he is not entitled. And that's why one of the essential part of the GI application is a method of production. And the second part is an inspection body. So those two are legally most important aspect need to be remembered. And hence, this is a legal right. So method of production, if there is a change in the method of production, instead of you are using the power loom instead of hand loom, then you are not entitled. Second, inspection body, there is a provision. I can give you the example of your Pashmina shop. They have a specific now inspection body in Maharashtra. I said 11 product. We are working as an inspection body. So authenticity is verified by third, genuine, respected person, legally, officially viable. So here, that gentleman who migrated and he continued with the culture, tradition, process, method of production, then with the help of registered proprietor, he can get authorized user certificate. Otherwise, he is not entitled because it may hamper the community's intellectual property. Hope it clears. Thank you.
Thank you, sir. Any more queries?
बाकी लोगों को जीआई पता चला है क्या? कृपया हाथ खड़ा करें. जीआई किसको पता चला?
Another query, sir, here.
एनी जीआई किसको नहीं पता चला? हाथ खड़ा कर दीजिएगा. नहीं पता चला? अरे बाप रे, एक आदमी है. जीआई किसको पता चला? अच्छा, किसको पैसे चाहिए? वाओ मैम, योर बॉर्डरलैंड इज सच अ रिच. किसी को पैसे नहीं चाहिए. Wow, they are satisfied. They are big, rich people. Okay, rich in culture. Yeah.
Sir, just had a small confusion and a doubt. Like, what happens when something goes cross-border? Like, I read a news that India and Pakistan are fighting for the GI tag for basmati, and in the similar vein, if Bodoland ask for a GI tag for something, and simultaneously Bhutan also starts to claim it. So how to decide, like, these are just boundaries, but the culture
First come, first serve. Now coming to your basmati. भारत ने रजिस्टर्ड किया इसीलिए पाकिस्तान ज्यादा हुआ और 2021 में उन्होंने रजिस्ट्रेशन किया. हमारा रजिस्ट्रेशन 10 साल पहले का था. वैसे हम लोगों ने पहले करने के बाद भूटान करना चाहता है तो उनको पहले फर्स्ट कम फर्स्ट सर्व वो वाला कंसेप्ट एप्लीकेबल होगा. नंबर 1. नंबर 2, what I have already explained, due to some urgency you migrated, but the original place remained intact. For an example, वाकावाकी हो या फिर आपका ओल्ला हो या फिर आपका नाफा हो, वो यही की मिट्टी से आता है, यही के पानी से बनता है. That's why I give you the example of Borsari Dam. जहाँ की मिट्टी, जहाँ का पानी, जहाँ का एनवायरमेंट, जहाँ का सुटेबल वाली बातें हैं, उसी में ही आपकी एडवांटेज छुपी हुई है, and that is connected to the GI, and hence GI map is one of the mandatory requirement for the GI registration. And about the Basmati, I do not want to discuss it in the open forum. I represent there in WTO. However, Basmati is rice growing in the foothills of the Himalaya. So कहाँ पे foothills है वो आपको बता सकते हैं, और ऐसे में larger interests of the community need to be considered. Thank you. Hope there won't be any more questions. है ना? इसका मतलब है सबको समझ में आया है या समझ में नहीं आया है? हाँ? अच्छा, thank you very much.
Actually, this is a very interesting subject. And when entrepreneurship is related, it becomes interesting. So now we will move on to the next resource person. Kerekoppa Ramesh sir, he is from NDRI. So please sir, the podium is yours to deliver.
Good morning to you all. I'm extremely happy that large number of students are there. So yesterday also I delivered a lecture on livelihood security. At that time also I saw a large number of students. So I modified my PPT yesterday night. So what for we are all here? If you get a job, $20,000, same amount is given in India. Where you prefer? You will be there in your place if you are getting same thing. Lakshmi and Saraswati should go hand in hand. If you are able to earn, you have to earn something using your knowledge. Knowledge is power. Today, many of you must be from biotechnology division and sciences. Patent has made your PCR mission cost 2 lakhs or 3 lakhs, 5 lakhs and all. Why? It is nothing but series of water baths. We are paying so much because of the patent rights involved. I think it's the rights created by the intellect of the individual. Today I will be talking for about 30 minutes on strategic use of intellectual property rights in livestock sector, but I will be not confined to livestock sector. I will go beyond that, and we have to use it effectively for the benefit of the mankind, particularly for our Bharat Mata. I always say we have to utilize it effectively. Earlier days, golden days, our forefathers' knowledge is to share, but now developed countries, they utilize it effectively their knowledge to make a developed country. We can never be developed country without using our knowledge power. We want to be developed country. We never want to be a developing country forever. If you want to be a developed country, we have to use our knowledge power. Today, USA is superpower. Why? They have got weaponry, they have got money. Their economy is mostly coming from weapons, sales of the weapons. Any war takes place over the world, they will be making money by sale of the weapon. India is importing so much of weapons. Our defense budget, so much is going to foreign countries because of the knowledge power they have. And recently, air show was there in Bangalore. I also attended. So many flights were there with different mechanisms, different benefits. That cost is so much in billions of dollars, millions of dollars because of the patents involved. Coming back to the borderland, I was in Sanjay lab yesterday. I was seeing some PCR mission, incubator, many things, pharma made and all. You have given in 5 lakhs, 6 lakhs, 10 lakhs. Actual cost, if you manufacture in India, same thing without giving any money towards IP, it will not cost even in thousands. Few thousands you can make it, but you pay in lakhs because of the IP involved. For example, I will take another 1 minute. Corona vaccine, COVID vaccine, if you would have not made in India, you would have sold our airport or all our water resources, hydroelectric powers. We are all safe today. I am in front of you, even though I suffered from COVID because of the vaccine available to our countrymen. For that, we have to thank our scientists. At the same time, our policy also. rulers, whatever they made. We are all signatory to TRIPS agreement, trade-related intellectual property rights, and also CBD, Convention on Biological Diversity. I had the opportunity to visit this place 2 years back as a PhD examiner for traditional knowledge. Somebody has worked on traditional knowledge, plant-based traditional knowledge. There are many extracts. Many things are there which we can protect and earn money. India is a very rich country, but only thing is we should know how to use it and make it a rich country. India is always a rich country. Many of us are poor because of our inability to utilize our resources. Coming to our livestock sector is the critical component of the Indian economy. Milk alone, if it contributes 5% to the GDP as a one single commodity, as agriculture commodity, milk gives more than the wheat, rice, and sugarcane together. Today, livestock sector is very, very essential for giving protein source to the humankind. You want many girl students I'm seeing, and also ladies are there. Everybody wants my son or daughter to be intelligent. If you want that one, lactoferrin, galactose, and all those things are required for the neuron development. Where it comes from the milk. Similarly, not only milk, meat, many things are there. I will be telling only one or two examples. Recently, my son he works in Freiburg in Germany. He came here. He is looking very well, 6.1 feet height, and I took him to Sagar Apollo Hospital for checking. B12 deficiency is suffering, even though he is in most of the vegetarians and so-called non-vegetarians in India, they eat weekly once or twice non-vegetarian. B12 deficiency is very common. For that, you get B12 from milk and other animal sources. Similarly, at the age of 40, 45, many software engineers that time are at the old age. Many of us fall in the toilets, bathroom, and all, break our bones because of osteoporosis. And if you visit any of the orthopedicians, they will give vitamin D3 and calcium. Calcium biggest source is milk. If you take 4 cups of milk, that is enough for the man. If you want same thing from egg, 60 eggs you have to eat. If you want to eat tomato 6 kgs you have to eat per day. It is impossible. So that is the source. Now I come to IP. We make many products out of that. Why can't we protect it? Dahi, many of us, our food will not be complete without dahi, curd. When I was in Arunachal Pradesh, Dhiran, I purchased an incubator for making dahi because we are so much accustomed. Dahi is one thing, it has got many biopeptides, many biotics, prebiotics, all these things can be protected under IPR, intellectual property rights, and we can get the. My predecessor speaker has explained very well about GI. Many of I'm seeing students, so I will explain more about patents. Yesterday I have modified after seeing the speaker's names and other things. I have gone through all their biodata in the website, so I modified immediately. Next one, please. I will be talking about in India, indigenous cows give only 3.9 kgs of milk, clapbirds 8 kgs of milk, goat 0.44 kg milk. Today, donkey's milk, it costs 20,000 rupees in Indian terms in European Union because of its medicinal value, beautification. Who doesn't want to be beautiful? Where many aspects are there involved in that. All those things you can do research and patent it or protect it under any one of the IPR system. And protection of yak is there in Arunachal Pradesh, Mithun is there in Nagaland and surrounding areas. It has got its own product. For example, yak milk, yakish milk comes. Churpi is one of the products which is made out of yak milk only. If you make from other milk, it will not come through the smell. And that aroma, that quality, and many of the things, anti-carcinogenic property, all these things it has got, you can protect it through appropriate means of IPR. Next one. What is IPR? It is the creation of the mind. If you have a land or if you have a building, you cannot take it to other parts. You cannot But if you have a patent, you can be inherited, you can sell it across the globe, you can sell it or you can inherit it. Knowledge is the IP is a key to techno-economic growth. If Infosys value is multi-billion, or Wipro or any other company, software companies have from Bangalore, software and biotechnology or biopharma, value is so much valuation because of the intellectual property rights. They won not because of the buildings or land. Without that IP, their value will be very, very less. Next one, please. Abraham Lincoln told IP added the fuel to the growth. Next one, please. IPR, you see, in the area of agriculture, biodiversity, you have got lot of biodiversity in your area. Northeastern region, cats you can find only in Himachal Pradesh, Arunachal Pradesh and surrounding areas. And similarly, Mithun, Nagaland, I am also a management IMC member of that institute. And biodiversity rich, we have got cattle, Malnad cattle, very small cattle, its milk has got 250 micrograms per ml of milk. And buffaloes have got 30 micrograms. Mother's milk has got 1000 micrograms per ml of. That's the reason all mothers, I request them to give their breastfeeding is a must for the growth of their children. They have to give. And when it is not available, you shift to cat, like goat milk or dog cattle like Malnad milk, which has got very high, which is very, very essential for the neuron development and also antimicrobial property, antiviral property. COVID, we don't have any drugs to treat COVID. We have to develop immunity. Now, yesterday news and 2 days back in NDTV and all, I was listening. China is developing super army personnel who can work for 7 to 8 days without food and water. Same way, these many things are there. We have to boost our immunity. We have to develop not only soldiers, but also each one of us should be ready to be soldiers. That can come through using various appropriate products. Next one. Biological Diversity Act and Conservation of Biological Diversity, CBD. India is signatory to both CBD, Convention on Biological Diversity, which gives rights to their genetic resources and sustainable use. Similarly, Biological Diversity Act 2002 was made in India to comply with CBD. If you use any of the plants available based on traditional knowledge, if you develop it, drug, if you want to patent it, then you have to indicate the source in our patent application. Many of you must be patent. Patent writing is not difficult. It is easier than writing an article if you are trained in that. Patent application filing is not costly also. It costs for individuals only 1,600 rupees. Yeah, small scale organization, it is only 4,000 rupees, and a bigger organizations like Bodoland University or anything, 8,000 for the application. Afterwards, you have to, for examination, you have to pay a little bit, and also publishing, you have to pay a little bit. Altogether, it is not in lakhs, it is only in thousands. And you have to cultivate that habit and make use of that. If out of that thousands of patents, if you file even 1 or 2 works worldwide, you will make billions of dollars. You can be a richest man in the world. Next one, please. And traditional knowledge is also very, very important. TRIPS agreement, you are signatory. We cannot say, I will not patent it, I will not use IPR. Earlier, my forefathers were giving freely, so I will also give free. That cannot. No America is giving, or China is giving, or no other country. Today, China is patenting, or they have got very liberal attitude towards patenting. So, you see, under Article 27.3, members must provide various forms of intellectual property in many of which are relevant to R&D in agriculture and also our own growth. Must grant patent and on all products and processes. Earlier processes we are not protecting, only products we were patenting. Some reverse engineering they started. That is the reason India and China were called as the biggest Xerox missions of the world. That is the reason America and European Union, they were not sending their latest technology. When they had the third generation car, they sent only second generation car technology to India and China. They made a lot of money because by the time they are able to develop third generation, they will be having fourth or fifth generation. That was the thing. But today, Apple phone, today, if it is released in USA, Washington today, within few minutes, we will be having in India, China, or any other country. Similarly, in European Union, whatever is available, that technology is available worldwide. That is because of the TRIPS agreement. Next one, please. These are the main IP instruments, patents. I will be telling in detail about trademarks. You know, trademarks, service marks. For example, if I go to a cloth shop, I go for Raymond's. Why I go for? Because of the belief and also quality assurance I get from that provider. Similarly, Infosys, the software is there, I purchase at a higher value. My previous speaker told about Parker pen. It costs so much, but if that label is removed, nothing. Similarly, today, Santos car or Maruti car we purchase because of the value we assign, because of the quality assurance we get to that. Similarly, geographical indication, my already he has spoken, Dr. Ganesh has spoken in detail, so I don't want to go into the details, but industrial designs are also very, very important. Layout design of integrated circuits, mobiles and circuits are very, very important. They are copyrights and related. All copyrights. If I write a book, whether it is good or bad, once it is in the form of a book or a CD or a movie or anything, it is protected. If it is in your brain, if you imagine, it is not protected. Quality is not important. Yeah, it need not be a good quality story. It can be bad also, very bad also. It gets protected, but need not be registered on anything. But copyright also can be registered. It is worldwide. Copyright is always worldwide. Whereas other are territorial in nature. If you protect in India, you will get only Indian patent. Trade secret. Trade secret. For example, how to make a product. You keep it with you and you make it. And you make a vaccine. Keep it with you, that knowledge. Sell worldwide and make money. That is the trade secret. If you develop the knowledge how to make dahi, that is curd, at room temperature, it will not be spoiled for 30 days. You make a culture and use it. That technology, you sell it. And Coca-Cola was kept for long as a trade secret. But now it is disclosed. Next one, please. IPR era, India operated without plant variety protection law intentionally, and 1970 Patent Act, even today, as amended from time to time, that is in force, excluded patenting of life forms, whether plant or animals were avoided. New seed policy, because of that, Monsanto and other companies came into India. Earlier, nobody was coming to India for investing in the area of plants. Patent and plant variety, BIKF authority in Delhi is there, came because of this TRIPS agreement. Similar instrument is not available for protection of animals. We are always requesting government of India through an act of parliament, similar to BIKF authority, one authority should come for animals. Next one, please. But we have got breed registration authority through NBA. Yeah. What is patent? It is a monopoly right. You can stop others from using. If you have a patent on making a vaccine through that method, you can stop others from using that. It is for a limited period. Patent in worldwide today is for a 20 years time. And it is a negative right. You can stop it. It is not a positive right. For example, PCR mission making. Many patents you will be using. If you have one patent, you cannot make PCR mission because other patent you will be violating infringement. It is territorial in right nature. Territorial means if you patent protection, if you have taken in India, you cannot you cannot say that I have protected in India, USA person should not make it in USA. But same material cannot come to India. Next one. These are the acts, patent and designs act. 1911 only it was there in India. And Patent Act 1970, We have Paris Convention, we have a signatory, Budapest also we were involved, and we have got amendment to Patent Act in order to comply with the TRIPS agreement. A couple of amendments have taken place. Biological Diversity Act 2002. If you are patenting something based on your traditional knowledge, for example, if you develop anti-cancer drug out of a some your incubation center, you have got some products, plant source. You have got some get the lead. Out of that, you are able to extract it and use it as an anti-cancer drug. Then you have to, when you apply for the patent, you have to disclose the source of the plant material, what you have used from where, and community has got a right over that. And similarly, geographical indication, traditional knowledge, library also has been developed in India. Next one, please. Next one. You see, in case of plants and animals, you can protect all the processes and products which are required. Our productivity is low. If you want to increase productivity, for example, if you are growing wheat or rice, productivity is low. In India, you develop a method that can be protected. Microorganisms and microbial processes. For example, dahi. If you develop a lactic acid culture which can keep at room temperature for 1 month, shelf-life enhancement, that thing. Efficiency in milk processing. For example, milk. You can keep milk from whether it is milk of yak, mithron, or cattle, anything for only 6 to 7 hours in tropical climate. One of our student, Ravi Prakash from Bihar, he developed one under our guidance. One ball, like similar to cricket ball. You keep it in the refrigerator. Next day morning, when you go for milking, you put that ball into milking pail. You milk it. Milk from 37 degrees, 38 degrees, it comes to 8 to 10 degrees. The milk keeping quality from 6 to 8 hours, it goes to 14 to 16 hours. That one invention has been patented by our institute because of my advice and suggestion, because I am a patent attorney also. And he got BRICS Innovation Award in Brazil, and also Getty Award from President of India recently. Similarly, you have value addition, safe handling of milk products, and mechanical devices to make any product. You make rasgulla making, oil frying. You know, one of our engineering student has made oil frying method. If you can use oil for 1 or 2 times only, you cannot use it repeatedly because anti-carcinogenic substances are produced. What he did was simultaneously, because of pressure, it will be boiling at a rasgulla is made at a lower temperature. Then that oil can be used many times. Even acrylic acid production will be reduced. So that technology, that type of technology, and the animal and human health, many drugs, diagnostics, vaccines, and organic waste, all these things, many organic waste is there. You are all effectively using, we have to use it much more effectively. Even energy generation, electricity generation from dung or anything, such things also can be patented. Many of our people have patented, but only thing is we are far, far behind many of the developed countries, even China. In 1989, when I was doing 88, 89, Indian economy and Chinese economy were almost similar. Today, their economy is 5 times more. For that, IT instruments helped them greatly. Next one, please. And even statistical methods they can use for patenting and DNA markers. Many of you must be working on sequences, DNA sequences that can be patented in India also today. Earlier, it was not patented. Transgenic animals that can be patented. Methods used for developing transgenic animals. Methods to measure traits. For example, what is the ability of this plant to withstand heat or salt tolerance. All these methods, whatever you develop, that can be patented. Computer software in USA it is patented. In India, copyright protection you can see. And many more genomic selection, proteomic markers, and for example, COVID diagnosis using RT-PCR. That recently we have done one of the technology based on the sperm antigen, surface antigen. We studied LC-MS analysis of the spermatozoa of the bovine. We developed some antibodies, and that one, if you put it, all Y-bearing spermatozoa gets agglutinated. Just like tea or coffee filtering, you filter it. At the bottom, when the X-bearing spermatozoa comes, we have done already. We have inseminated 40 cows. 90% we get only female cows. That was apprised by our honorable DG to the honorable President, Prime Minister of India, and a few days back. And he also referred in one of the meetings. Next one, please. And IPR issues in the field of livestock sector, there are many issues are there. For example, if you alter a dog, all puppies coming out of that dog, they may not have that gene. Whether patent protection will continue in that where it is not come, or in the puppies which has got, that is a major issue. Next one, please. Similarly, if you are not protecting properly, many multinational companies like Monsanto are becoming the owner of many of our knowledge. For example, Bengal, many of my friends from Bengal are here. This Borula gene, Borula is a gene which is responsible for twinning and triplets in case of Bengal sheep. That gene has been patented in New Zealand and some other Australia and other countries. Basmati rice, when it was patented, lot of turmeric, lot of hue and cry was there, and thanks to Mashelkar, who was CSIR, he was in charge, and because of that, it was fought in the International Court of Justice because of one Urdu literature which will win the turmeric patent, reverse it in American. But in Borula gene, which is from Indian genetic resources, but we are not able to fight because not much emphasis is given, but that is very, very emphasis. And it should be given. Next one, please. National scenario, in order to fulfill the obligation, we modified the Patent Act. Harmonization of the IP is a must. Access to technology is required for genomics, biotechnology, and all these things are very, very essential. If patent protection is not there, nobody will invest money. For example, if you want to develop a vaccine, billions of dollars are invested, billions of dollars are invested, clinical trials, drugs, and other things. For that, protection is a must. If you protect it for a limited period, one can make money, and it is a reward for the invention. Next one, please. It is a simple one case of compulsory license. I will give an example. Netco is a company which was producing Naxavel, trade name. Sorafenib, it is a drug. It was used for kidney and liver cancer, and one of the cricketers was suffering. He can afford 2.8 lakhs per month that drugs he was taking. But one Netco company from Hyderabad, they told Bayer, who was the original holder, we want to make it in India and sell at 8,800 rupees. But they were not agreeing. They went to IPA, Intellectual Property Affiliate Board, which is located at Ahmedabad. Then it was granted. They made it, and they gave a royalty of 6% and sold at 8,800. We have got millions of patients suffering from cancer, and many people are benefited. That is one example gives the benefit of patenting and compulsory licensing. We should use effectively compulsory licensing. Patent can be inherited. If you are the patent owner, it can be inherited. Your son, daughter, you can, instead of giving property, you give the patent. You can make money. Sold, it can be sold to other company or anybody. It can be purchased. It can be licensed. Licensing is if you are inventor. For example, Bodoland University invents a molecule which has got a anti-cancer or anti-aging. Yesterday, I was discussing with somebody, and they were telling about anti-aging property and all. I was thinking I should work on that. I should be able to isolate that molecule. And anti-aging, there is a lot of demand in the worldwide market. We should be able to use it. That can be licensed, but making it as a drug, you don't have the potential. But you can license it. You can be license it in total. That means others cannot make it, or you can give to many people also license and make money. That is one way of getting money. Researcher also. Otherwise, you will not be interested in research. Wherever more money is given, and they will go. Abandoned, it can be abandoned. For example, if you develop a vaccine for COVID or similar, lumpy skin disease is there. Today, many animals are dying. I was few days back in Rajasthan. Many gold merchants and diamond merchants, they were discussing with me about diamond, this lumpy skin disease. What is that? How to do it? Vaccine. If you are developing a vaccine, that has whoever develop in the interest of the mankind and livestock, he can abandon it. Anybody can use it and come out with the vaccine. Patent can be defended against infringement. You have the patent owner. If somebody uses, that can be infringed. Then it can be revoked by the government also. Next one, please. And you see why we should patent it. Somebody may rediscover the same thing and use it. Reverse engineering. If you sell your molecule to USA, they will analyze it, reverse engineering it, and make by other means. That should not happen. That is the reason. And you have to get loans and other things. Many of my students and our students are getting awards because they are protecting patents. For example, even Jawaharlal Nehru Award application I am seeing in ICR or Government of India application, if a student has got for his PhD patent, granted patent, then he will have a better chance to get awards, rewards. And also some entrepreneur will come forward for investing his money if he has got a patent. Risk of patenting, you will be publishing the way how you are doing, known to the public. Because any patent application, it will be published in patent journals. Today, I can see worldwide patent journals and what are the patents going on. And infringement is difficult to detect. My daughter is a fashion designer. She makes a lot of silver article designs. Then she has to have a lawyer to fight her cases. That is today's world. Trade secret status can be destroyed. For example, if you have got something as a trade secret, if some employee goes away, you will be having agreement, but he will start his own. It is very difficult to fight. It takes long time and all. So nobody can do if not licensed. Next one, please. Patent laws apply to all areas, including agriculture, industry. It is in atomic energy in India, atomic energy areas, most of them which are related to defense and all cannot be patented. In the field of biotechnology, it is difficult to distinguish between discovery and invention. Invention can be patented, but not discovery. If it is naturally occurring something, if you take it and it cannot be patented. Next one, please. What can be patented? Any process of making some drug, machine, PCR, gel dot mission, manufacturing of any product can be patented. The process of manufacturing, composition of matter. For example, if you add some ingredient, make it anti-diabetic, that can be patented. Any use and useful improvement thereof also can be patented. For example, something is there, it is an anti-carcinogenic. If you add something, or if you identify a new use, it is also anti-diabetic, that can be patented. Next one. And but for patenting, US Supreme Court has told three things. Anything under the sun can be patented as long as it is inventive, novelty, newness, and non-obvious to the person trained in the art. For example, biotechnology patent. Biotechnologist is the trained in the art, capable of occupation, utility. It may not be present utility, it can be anticipated utility also. That can be patented. Next. You see, priority date, the day you apply, you get priority. If you are PhD students, if you publish your article, then you cannot patent it. If you are an engineering student, if you make a mission, you sold 1,000 units in the market, then you cannot patent it. Before publishing your article or you are publishing your thesis as a book form, you have to patent it. You have to apply it. Granting it takes time, no problem. Next one. Non-obvious means it should not be obvious to the person trained in the art. Next one. It should have utility, industrial application. You should be able to come out of a product. Next one. Who gets the patent? Patent is given to the inventor If you are working for Bodoland University, you will be holder, you will be the researcher who has invented and assigned, you can assign to somebody or any legal entity, you can say these are the legal entity also can hold the patent. Next one, please. Turmeric patent, lot of international court of justice people fight because of this one, and it was revoked because of the CSIR intervention. Next one. Procedure for filing. You have to file an application form. Application you can take help of patent agent. And I write my own patent application because I am also a patent agent also. Any of you who are interested, they can write patent agent examination. You need not have to do. I did my masters in patent law and also my PG diploma in IPR. Just because I attended this type of one conference, I was interested. Next day, I registered for PG diploma. Afterwards, Geneva, WIPO, they invited for master degree in IP law. So I attended that one, and it is not that difficult. Many of you may be thinking it is very difficult. I read only 4 days, and I passed patent agent examination. But you have to devote your time. I'm not from the patent law side or anything. I'm basically a hardcore animal geneticist, biotechnology scientist. Sandeep Das recommended me for his PhD. You see, you have to apply. Examination of the application will be done only when you apply for it. Patent publishing has to be done. That will be done after paying some fee, and it will be accepted if nobody opposes. And overcoming the opposition is and renewal of the patent. If you get the patent, if you sleep over it, you will be losing the right. You have to pay. Out of the patent granted, only 15% gets inquiry, less than 3% gets commercial stage. Out of that, less than 1% only works. Next one, please. And you have to application form and other things, fees and all triplicates you have to apply. Next one, please. And what is the cost of patent? I have already told. If you submit in physical form, 10% more. If you submit online, it is 1,600 only for individuals, 4,000 for small entity, 8,000 for large entity. I want to make it very clear to my students, friends. You can also patent it. Definitely, it is not a big thing. You try, you will get it. Once you get one patent, you will be applying. Last year, from our SRS Bangalore, 8 patent applications we applied. This year already 6 have been filed. Next one, please. Convention application. There are 3 types. You can apply at Indian level, Indian Patent Office. Convention means European Union is a convention. Some convention countries you can apply. Next one, please. International patent application, say that is PCT, Patent Cooperation Treaty, you can apply through WIPO or Indian Patent Office, you can apply so that you will get. If you want to get your patent in America, Australia, many other countries, you go through PCT route. You need not have to apply in their language. You can apply in English or whatever the language you are allowed in Indian Patent Office. Next one, please. There will be opposition. Pre-grant and post-grant, both are possible. If you are the inventor, somebody takes away, your lab mate takes away and files, patent application gets it granted. Afterwards also, you can prove, you can apply for post-grant opposition. Next one, please. Next. Patent, next. Here you will come to that. This is the way one gets the patent. Earlier we used to take 4 to 5 years after applying. Now it is coming quite quick. Singapore, for example, within 6 to 7 months we are getting patent granted. India is also becoming quite faster. It has to become further fast. Next one. You see, patent holder, he can be a farmer or anybody, student or a university. They can sell it, license it, contract and multiplier. They can sell it and make money. Next one, please. In biotechnology, product, process, research tool, operation, method of use, all these things can be patented. Next one, please. Biotech patents, for example, if you patent a sequence, if you make a small change also, it is very easy to make. So you have to take doctrine of equivalence, they say. So always use similar to and all those words. Next one, please. Many modifications as far as possible in the application itself. Variants with 80% or more similarity, all those few words should be used in claims. Next one.
मालूम नहीं क्या
Patent nucleotide sequences, now it is possible. Product
digital government में ना है laptop अच्छा लगा मुझे
sequence
laptop अच्छा लगा मुझे
provided they are isolated from natural
खबर था
substances,
आपको मनीषा
but utility is proven. Without proven utility, you cannot patent, even in India. Next one, please. Animal patenting, Anko mouse, cancer research they use it, that was patented. Dolly, it was patented in UK. Next one, please. And many modifications are possible. Next one. And patenting of animals, for example, sexing of semen. XY Inc. has patented for sexing of semen. That is the reason, including your state Assam, 1,200 rupees per straw you are paying. Actual cost will be 20 rupees and 30 rupees. If you develop your own technology, it will become much cheaper. Next one. Many controversies are there. Borula gene is there. Milking methods. Next one, please. This is the first patent on clone Swiss dolly. Next one. Genetically manipulated organisms in New Zealand, they have patented. Belgium, New Zealand. Next one. Next. And this is the patent. For example, these are the two patents recently I got it. Couple of more patents I have got. Jackfruit in Assam also you have got. After eating the jackfruit, that it goes as a waste. If you feed to the animal, jackie smell comes in the milk. In order to avoid how to do it, avoid that. If you make it as an animal feed and feed it, jackie smell will not come in the milk. That is what the technology we have developed, that we have patented it. Somebody has come forward to commercialize it. Next one, please. And trade secret, I have already told, trade secret is any sort of information that can be used in a business or other concern. You can, for example, dairy making, I am giving repeatedly example. Coca-Cola composition was not known for many years. They made huge money. Next one. Next one. Trademarks, Maruti, or Hilton, or GM, Raymond, so all these things are trademark. Trademarks are the word, name, symbol, or device, or combination thereof, which indicate the quality or source and other things. So GA also indicates the source, but here who is the manufacturer? That type of information is given. I will give the PPT. Any of you are interested, particularly students, they can use it. And Amul sued for Nestle for 10 crores recently. This is you see now trademark, trade secrets, everything is becoming very, very important. Next one. Geographical indication, I don't want to go into the, for example, Dharwad Beda, which is made in Dharwad region that has got a specific flavor and taste. Similarly, Churpi from yak, it is made in Arunachal Pradesh or Himachal Pradesh. That has got a definite aroma, definite taste. A Bangorian like me, I cannot taste it and I cannot enjoy. But many of my friends in Delhi, they used to ask me to bring churpi from Arunachal Pradesh when I was working in Dhiran. I used to take, they enjoy. That is the Indian cultural heritage. Similarly, Bursi breed of chicken, it was grown in designated area in France and that is sold at 40 to 50% higher price. Similarly, Sambucana chicken in Sambucana sheep in Italy, it is also sold at a very high price. Similarly, in India, we have got Chivika buffaloes, many varieties of buffaloes, cattle, sheep, goat, mutton, all are there that can be protected and a geographical indication we can get. And for example, Kefir also contains alcohol. It is the product used in Russia and other cold areas. Army personnel they were giving regularly because alcohol level is low and also it is a stimulant. It works as a stimulant. Next one, please. All these things. Next one, Dharwadi Peta, Agra Peta, all those things are protected industrial design. Next is the copyright. Copyright is worldwide in nature. Definition means you can apply to next one. Yes. Copyright applies to literary works, dramatic works, musical works. Music, you must have seen movie, Bollywood and other places, so much of controversy and court cases. Artistic work, the way the artists do the work, cinematographic film, all these things are protected. If it is in the mind, it is not protected. Once it comes in the form of a CD or some literature form, it is protected. Section 14 of the Copyright Act. Next one, please. Yeah, it should be original. It need not be good or bad. That is immaterial. It has to be original. The work has to be in tangible form. That means CD form or a book form or something. It has to be under one of the category mentioned in the expression part is protected, not the idea part. Utility, all these things can be protected under copyright. Next one. Scope of copyright, you can reproduce it and you are going backwards. You can reproduce it if you make a story that can be made as a cinema, art, drama, something, all those things. You can copy it. If you write a book, others cannot copy it without your permission. But if you give permission, then it can be copied, it can be adapted, 2-dimensional, 3-dimensional, all those things can be done. Next one, please. Need of the hour is to protect our intellectual property rights, make use of intellectual property rights to increase our economic growth, GDP growth, and make our own scientifically knowledgeable and also use that for the benefit of the country. Next one. We have to create awareness. We have to create IP production should become at colleges and universities like Bodoland. It should become a culture. Next one, please. IPR and other instruments should be effectively used to make Lakshmi and Saraswati should go in hand. Whatever the Saraswati you have got, convert it into money. Everybody wants money. So you make it and let all of us grow with IP knowledge and let us make our country a developed country with that hope. Many production let it come through Bodoland University. Let Bodoland Universities all the growth come through the royalty, earn through the patents, and many of your salaries also should come through the revenue, earned through your patent or trademark or something, whatever the IP instrument. That is the way. Today, if Oxford or Harvard number 1 or 2, that is not because of the some just publication coming out. It is because of the revenue earned through IP. Yeah, when I was in John F. Kennedy School in Harvard University, there, any paper, if you have to publish it, it should go through an IP attorney, whether it has to be protected or it can be published. They will say, then only we should publish it beside. Same way, let us all progress with that remark. I want to thank the organizers and Dr. Sharmita Brahmakaur, Dr. Sandeep Da, and all the organizers from this organization for giving me this opportunity. If you take forward, I'm highly email friendly person. Any of you can approach me through my email, kpragb@gmail.com, K for Karnataka, P for Punjab, R for Rajasthan, A for Apple, G for God, B for Bangalore @gmail.com. Thank you so much.
Thank you, sir, for your elaborate discussion on not only the basic concept of IPR, but also the use of IPR in R&D industry, including livestock sector. Livestock sector, which plays a very important role in the Indian economy, because most of the population in India is dependent on livestock for livelihood generation. So thank you so much, sir, for your very informative lecture. Now it is open for interaction. Any question is welcome. Any query? Yes, sir.
Respected sir, the session whatever over just now are very important for our daily lives, and if we can achieve such technology or methods, then we can live up our societies and our lifestyle. But one matter is there, according to me or some of my friends, since we don't have anything such that handbook, pen, module, etc. So we are just becoming like the guardians. We don't have any record. Then how we can learn feedback later? Okay. Actually, this is not your responsibility, but this responsible depends on the management committee. That's all. Thanks.
Thank you so much. In this hall, anybody is having any person is there without mobile? I don't think. internet is available in your mobile. All of you are having. Just go to intellectual property rights website. You know, if you just click IP, Government of India websites are the Director General of Patents and Trademark. All these things, if you go, copyright, you type it, it goes. Such a simple language, any common man can understand that language. All those things are put it in the guidelines. Even I have written one article for you. I have written in a very simple way. You can go through it. And further things, whatever you require, patent attorneys are available in Guwahati also, nearby places also. And you can become yourself patent attorney within few days as patent agents. You need not to practice it and it need not be livelihood. Within your university, one of the teachers can become a patent attorney. They can draft their patent, and wherever difficulty is there, they can consult experts in that field. Definitely, it is possible, and most of the things are available in the public domain online. Just you click your mobile, you check it, and it is available. Thanks to Government of India.
We also have an IPR cell in our university. So for any assistance in that matter, you can approach us anytime. Thank you. Any more query? So we are running short of time. So let us proceed to the next speaker. A big round of applause for Ramesha sir. Now we would like to invite Dr. Sanjeev Paul, scientist from IICT Hyderabad. So the podium is all yours for your deliberation.
Thank you, Madam Sharmishta, for giving me the opportunity. Namaste, brothers and sisters. Kulumbai. So I am very privileged here to attend this program as an invited speaker because I feel privileged because my residence is 40 kilometers from here. I am from basically Dhubri. So I am familiar with this region, and my previous speaker from NDRI, Dr. Ramesha sir, has elaborated several things which are in my presentation. So I will quickly move which are already covered. Okay, so as I was a patent examiner in Indian Patent Office, and later I joined in CSIR in R&D organization. So in my presentation, I will try to connect the insight from Indian Patent Office and try to expose you how R&D organizations are performing well in intellectual property protection, and how academic institution can reap the benefit from this insight. And this my presentation will be particularly with special reference to our beloved newly formed, we can say newly structured, that BTR region, our beloved BTR region. So let's move ahead. So as my previous speakers already spoke about intellectual property, what is intellectual property actually? Whichever property we generate from our mind, the capabilities of our mind, that is the capability of our intellect, those are basically called intellectual property, and the right involved in that particular intellectual property are the intellectual property rights. So our creations of mind may be different, right? It may be scientific way, it may be artistic way, it may be literary way, it may be a different kind of creativity our mind can produce. So the types of intellectual properties will also differ based on the types of creativities, right? So please move ahead. So here you can see what are the types of intellectual properties recognized throughout the world that my previous speakers already told, that it may be patent, it may be trademark, it may be copyright, it may be industrial design, it may be trade secret, or it may be plant varieties, or it may be integrated circuits that are used in our small chips used in all electronic devices, right? So in those chips, there are various tiny those designs that are also protected in the form of intellectual property rights, right? So here the trade secret, though there is no as such legal provision to protect, but it comes under the purview of common law. Okay, so next. So here you can see that how intellectual property, different intellectual properties are governed in our Indian framework, right? So basically, the most of the intellectual property rights are controlled by Ministry of Commerce and Industry, under which there is a subordinate office called Office of the Controller General of Patent, Design and Trademark, that basically govern or control the different intellectual properties like GI, like just industrial design, like trademark, or like patent, right? So there are respective offices in different cities across the country. People can file their intellectual properties in those particular offices physically, as well as nowadays online provisions are also there by the use of e-signature. Okay, digital signature, not the soft signature. There is a digital signature that has to be procured from e-mudra or some authorized signature providing agencies. So with that, we can file online also with a reduced fee for filing each intellectual property rights. Okay, so these are the acts and rules basically those control or those governs different intellectual property rights. Next, please. So here, these are the other intellectual property rights. Those are governed or controlled by different other ministries, like your Department of IT controls the semiconductor and integrated circuit design. Then your plant directives controls by that ministry, Department of Agriculture and Cooperation. Okay, so in that way, these intellectual property rights are governed or controlled by from the government perspective. Next slide, please. So, as about the patents, the elaborated discussion was already done by my previous speaker. So, I will not go with the depth of this. I will just only say that it is not a new concept in our country. During British era, it is going on. That patent system in India was initially introduced in 1856, but at that time it was not completely structured. But since 1911, the formal act came up, and after that, in 1970, we got our post-independence full-fledged own Indian Patent Act, and after that, we have amended that act several times to comply with different international treaties that we signed, including the PCT and that is the TRIPS agreement and all these things. At that time, to comply, we have introduced the product patent. Earlier, the product patent was not there, but later on, we started giving the product patent from India also, and patent term was extended to 20 years to comply with the global requirement. Next, please. As my previous speaker already told, that for patenting there are three major criteria. Though patent is a territorial right, that you know that individual country has to give the patent protection, but these three criteria are common in almost all the countries, because that World Intellectual Property Organization, that is WIPO, through that WIPO, this criteria remains almost the same, though some technical aspects may differ. Like some country tells as ordinary skill in the art, some country will tell the skill in that art. So some technical word difference may be there, but more or less you will find the same. For patenting, every anticipated or prospective invention should have novelty, inventive step, and industrial applicability. Novelty means newness. It should not be a mirror image of previous one. Inventive step means it should not be obvious for a person skilled in that art. That means a person trained in that particular field should not think or perform that invention by his own without having any intellectual contribution into it. So that is that will fulfill the requirement of inventive step or non-obviousness. And third one is the capable of industrial applicability. Industrial applicability that will be either that invention should be utilized or maybe produced in industries. Okay, so these are the basically three requirements for patenting. However, after complying all these three criteria, also we may have to have certain restrictions to our in our act for patenting. So in patenting, you know that patent is a monopoly right. So there should be a social balance also. A company or a person that sir, in my previous speaker's presentation, you have seen one slide. He mentioned about a compulsory licensing thing. That was the NATCO Pharma and Bayer that litigation fight that compulsory licensing thing was going on. That is the for a anti-cancer drug. And I am happy to inform you that for NATCO Pharma, the scientist that was involved to work on that particular compulsory licensing thing on behalf of NATCO Pharma, that scientist belonged to my present organization, that is Indian Institute of Chemical Technology. He was Dr. Ahmed Kamal. So I also handle those things also in my organization. So you can say that how the price can increase in an enormous way, right? By giving a monopoly to a particular company. So it may not be effective every time that that patent can be provided in all the products. So to maintain social balance, our act has every provision. We have section 3 for such kind of things where non-patentability aspects are covered. What are not patentable? And section 4 basically governs the things which are pertaining to the defense and atomic energy related matter. Those things are because for the interest of our country's safety and security, that section 4 and section 35 basically covers all these things. And section 3 basically covers the non-patentable inventions. Next, please. So these are the basically inventions which are non-patentable, which comes under section 3. Like if the invention is a frivolous one, which is contrary to the existing natural law. Suppose it is a gravitational force. You propose a gravitational force moving upward. That those kind of contrary, which are contrary to existing natural law, those will not be patentable. In similar way, if some invention destroys morality of certain community, or if it is a naturally existing living or non-living material, or if it is a new form of a known substance, or if it is mere admixture of two or more substances without any synergistic effect, or if the invention is basically mere arrangement or rearrangement of the components, or if it is a plant part or as a whole complete plant, those kind of inventions are basically not patentable and comes under the purview of section 3 of Indian Patent Act. Similarly, if it is a mathematical model, next slide please. If it is a mathematical model or a software program, or if it is a traditional knowledge, those things are also not patentable under section 3. Next slide please. So these are the section 3 restrictions that are covered under this Indian Patent Act. Next slide please. So this is basically the procedure of Indian patent granting procedure. My next presenter belongs to that thing, and he will be presenting in detail. So I will not go in depth of this particular slide. Here, just I will say after filing, basically the major steps are after you file in the Indian Patent Office, you will get an examination report that in case of journals, if we submit a paper, we get reviewers' comments, right? So similar way, we will get the first examination report, and we have to prepare the response, objecting or to justifying our stand in response to the objections, and we have to submit our response. Then there may be a hearing call, and we have to attend the hearing in Indian Patent Office. Nowadays, these hearings are also conducted in virtual mode through video conferencing, so no need to visit that office several times. Okay, so in that way, after hearing, if we can satisfy the controller of Indian Patent Office, that patent will be granted. So this is the basic major steps of patent filing to grant. Okay, next slide, please. So, as my previous speaker already informed you that previously in Indian Patent Office, basically it took more than 5 years, 5, 6, 7, 8, you can expect 10 years also from filing to grant. But nowadays, the time, how the scenario is, I will take you inside how the scenario at present in Indian patent patent system. Next slide, please. So you can see that the scenario here, the trends in last 5 years with respect to filing of IP, how we have filed, how in our country the patents are filed, or other IPs like design, trademark, copyrights are filed. You can see that year by year, our country progressed in a significant way in terms of filing of, we can say, patent or trademark or design or copyright, right? That there is no such year that you can find dip, right? During COVID also, our country's IP filing has increased significantly year by year. Next slide, please. So why this increase has happened in Indian Patent Office? Recently, since last 10 years, if you can go inside the Indian Patent Office, you will find that there are significant increase in scientific manpower happened in Indian Patent Office by recruitment of patent examiners in bulk. Since 2012, these things are happening. In 2-3 years, there are 300 to 400 examiners are being recruited by Indian Patent Office. So they have the manpower to handle now to reduce the timeline, right? Then next, the procedural simplification. As I told, that hearing you can attend virtually from here. You can file your patent online from your desk itself, right? Then you can handle the prosecution matters also, filing submitting your first examination report, response, and all these things online, right? So due to those procedural simplification and also reduction in certain fees for women, for educational institution, for startup. So in that way, reduction in the prosecution and different fees, this patent filing has increased significantly, right? And timeline of filing to grant also reduced. So, but the question is, how we stand in global landscape? We have increased, we have performed well, that is correct. But where we stand in global scenario? Next slide, please. You can see this is the global scenario of patent filing. Here you can see again the patent filing of China, US, Japan. They are the dominating countries. India is standing in the 7th position. But though we are in 7th position, we can say by for namesake that we are 7th in the globe. But compare the numbers. Is the number comparable? Not at all. It is very less, and this is significantly less. So though we have increased, we performed well since last several years, but our performance, though we have done, but it is not standing well in global perspective, right? Next slide, please. So I will just try to analyze where the lacking is. This is the top 10 R&D institutions or R&D organizations that are those are filing patents, right? Here you can see that CSIR, that is my own institute, is the leading institute in R&D organization with 223 patents last year, right? And 10th one is filing 9 patents in a year by these top 10 R&D institutions, right? So you can see the disparity. Next slide, please. Same thing is happening in the academic institution also. You can see the top 10 academic institutions who are filing the patents. You can see that Sanskrit University is filing more than 700 patents, and later on, the 10th number institute is filing 126 patents in a year, right? I am telling about top 10 institutions, but we have more than 2,000 universities in India. So you can imagine that what will be the position of 2,000th university, right? So how we are continuing. Here you can see another observation from here. You can see, in addition to the government universities, there are several private universities, though they are playing very great role in IPR filing, because I will tell you after some time, because there are several reasons why they are doing so and why our government universities are lagging behind. Next slide, please. So this is the state-wise distribution. State-wise distribution also you can see that Karnataka, then your Maharashtra and Tamil Nadu, they are the top three patent filing states. And you can imagine the developmental reach of these three states in our country, right? Our Assam standing in 20th position out of all the states, and where we are contributing for 0.5% of Indian total patent by 3% of population, right? If we compare with the population with the patent filing, then we will see that 3% population is contributing for 0.5% patent. That means we are quite lagging in terms of this thing also, right? So though we can see in our Assam, there is significant increase also from previous year to this year, right? But still we are lagging a lot. Next slide, please. So you can see that I already told that there is no comparative similarity between the institution. There is no comparative similarity between the region. Then there is no comparative similarity among the institution. So there is lots of dissimilarities. So we can say that, so what? Dissimilarity is there, so what? What IPR can do? Next slide, please. This is an important slide. You can see that here you can see that year-wise from 1970 to present time, it is distributed as the market share with tangible and intangible properties, right? So we know that tangible properties are those we can physically touch or physically we can feel. Intangible properties are those we cannot touch or cannot feel, right? IPR comes under that intangible properties. You can see that market share from 1975 to this 2020, you can see that how that intangible property, share of intangible property has increased with time. And nowadays you can see that how much market share is captured by intangible properties in compared to tangible properties, right? So how IP is dominating in the market, you can see that intangible properties covers that invention, brands, customer data, softwares. You can say that now time is coming for chat GPT, right? You can type anything and you will get the result. What are those? Those are intangible properties, right? So you can say that Microsoft is with the chat GPT and Google is trying to bring their bird, right? There is another competition between those things. So this is happening, and these are the multi-billion dollars game, right? So they are basically capturing the market. So you can understand now that how important the IP is, right? Next slide, please. So here, these great men are explained how IP is important. Right? Somebody is telling that it is the oil for 21st century. Right? That in 20th century we can understand that how natural oil played the economy. In 21st century, that IP is going to play that same role. Right? That is the anticipation by those great men, right? And somebody like Bill Gates told that intellectual property has the shelf life of a banana, right? We can see that now today if Apple one version is released, then after 1 or 2 months or 3 months, the next version is ready to launch in the market, right? So in that way, if the shelf life is very less, so IP things are very rapid also. Next slide, please. You can see another thing, another slide. Here you can see the market shift in for Asia. You can see that 10 years back, that IP driven IP dominance in the market was 51% in Asia. Now it is in 66%, right? So what it indicates that Asia is going to dominate this century, right? We usually say that Asia, this 21st century will be the Asia century. India will become Vishwaguru, right? So those things are not the word of mouth. These are some facts going on behind. So we are our leaders are uttering those words, right? So next slide, please. So we can correlate the GDP with our IPR status also, right? So you can see that great major GDP holding countries are also holding the major share. In that way, what we can see are directly correlated to enhance or boost our IPR regime also go parallelly in hand, and this area also needs to be boosted, right? Next slide, please. So we have understand that how IPR is important, right? Earlier the question was that the similarity and all these things are there. So what? Why IPR is important? Now we have understood that IPR is very important for social upliftment, right? As the first speaker told, how GI can play in GI tourism, music tourism, then health tourism, all these things, and entrepreneurship and all these things. So the social upliftment is also directly connected, right? Then economic upliftment or GDP, this is also very directly connected with that IPR. Then human development index, then your innovation index, these are also connected with the status of IPR. In addition, for academic institutions like Bodoland University to have a good rank in you can say NIRF or NAC or Times Higher Education or any international ranking agencies, they have the major portion on IPR. Very important portion in IPR. How much patents are filed? How many patents are granted? How many patents are licensed? How many patents are commercialized? Those paras are there which have certain points, and it is added into the ranking things. So the upgradation of the academic institution, those things are also essential, right? Next slide, please. So now question comes that why not the uniformity among the organizations and also the states? The major reason that we can analyze that there is lack of awareness in several institutions and regions. There are several inventions. There are very good papers we find from different universities and organizations, right? From Bodoland University also, I have seen several good papers published in the journals, and I have seen that this could have been converted into patents right? But those were not filed, right? So similar way, there is not uniform developmental reach. So our northeast is not at par with, we cannot compare with Bangalore or Mumbai, right? So developmental reach with industry connect, we do not have that much. So if industries are less, then you can say that patents, the importance of patents we will not understand properly, because if the patents are not commercialized, the true value of the patents cannot be capitalized, right? So there are lack of state IPR policy or institutional IPR policy or guideline. Every state do not have that IPR policy. Every region do not have IPR policy. Those we as a whole for India we have one IPR policy, but all the states do not have, because we did not understood the importance till now, right? So there is no IPR licensing ambience in the institutions. If we license for creating such IPR licensing ambience, there should be those manpower also available who can search the industries and promote the technologies, right? And also proper profit sharing mechanism on licensed IPs, that if IPR policy is not there, then profit sharing mechanism will also not be there properly, right? Because somebody invents from Borderland University. Borderland University will be the owner of that IP. Now it is licensed. Now, after licensing, revenue will be earned by Borderland University. How much portion will be shared to the inventor? How the inventor will be motivated? Those policy-wise guidelines should be there in place. Otherwise, how inventor will be motivated and how inventor can bring the licenses for the university, the synergistic effect will not be there, right? So in most of the universities, availability of technological manpower is also not there with respect to the patent filing and prosecution related handling things. IPR sale may be there in all the universities because there is certain requirement of that, right? Some of the good universities also created IPR chair professors, but in most of the cases, there is no IP person holding that chair. The in-house person is meeting the criteria some way, right? So the purpose is not properly served actually in that context. So then dedicated courses on IPR is also very less in our country. You can say some of the universities or institutes only provide the PG diploma. If you try to have the masters for non-law on patents or IPR, you will not find such universities or institutions. From this year only, that National Law University of Maharashtra has started one course only in entire country. Next slide, please. So it is not like that the government is sitting idle. Government has also initiated several steps, like you can say that National IPR Policy 2016. At that time, I was also involved in some way, some distant way in this thing when I was patent examiner from IP office. So in that IPR policy 2016, the creation of IP cell was also a mandate, right? So then creation of chair that I told, that chair professor in IPR in the universities. Then then you can say that different commercialization and technological procedures are also simplified through that IP policy. Next slide, please. In addition to that, there are several other initiatives taken by Atal Incubation Mission, then CPAM cell of Ministry of Commerce and Industry, whatever we can say, cell for IPR promotion and management. Then Women Scientist Scheme on IPR under Ministry of HRD, that is also one scheme run by the Department of Science and Technology through TIFAC. And also several states have their own state patent facilitation center. And in addition to that, recently, from last year, the Indian Patent Office has initiated that NIPAM, that is National Intellectual Property Awareness Mission from last year, and also some series like IP Manthan and all. So these are the steps being taken primary way, we can say. So after this step, we are seeing some fruit in this domain, and several activists are also working for facilitating and promoting those things. So we are seeing some fruit at present, but lots of things to be done yet. Next slide, please. So, as I am the son of this region, so I know how potential BTR is with respect to IPR, right? Because where the indigenous people are there, where the tribal communities are there, we were the creators since long history, prehistoric time, right? We have created weapons for our livelihood. We have created our clothing by our own, right? We have created our agricultural instruments. We have created our different things since prehistory. The human civilization was not there, right? So we were the creators. We were the engineer at that time. Now we are following the West, right? So as the inaugural day, I can recall that Sonam Wangchuk ji from Ladakh, in his speech, he told that to become Atmanirbhar Bharat, Atmanirbhar can be created by our own things, not the things from West or not the things from Delhi, Mumbai, like that, right? So our own tradition, our own culture, our own things should be protected first. So as sir told, our first speaker, Ingere sir, he told that the potential of GI, and he is involved in registering some of the GIs of our region, right? There are several things to be protected under GI, right? From our region, and also industrial design. Why not we can protect the color combinations of our those attire, which is really unique, right? We can check for it whether it passed the novelty criteria or not. We can think for it, like traditional gamcha. Then those bags that are given, those color combinations. Why not go for the design registration, right? Then different attires. So in that way, there are very high potential for this even fermented fish. That if we include, if Bodoland University take the lead for entire Lower Assam, we can include that Rajvanshi community also. There they have their own thing that can be also protected, like their patani, their dried jute leaves, that is called shukati. Then fermented, they have their own fermented fish that is also consumed in this region, that is called shidol. Those things are also have very great potential for GI, but we people have to come forward to do such things, right? So so in this other way also, that for potentiality of the patents, as Bodoland University is the leading institute in this region. So this institute, along with some other that Bindeshwar Brahma Engineering College, CIT Kokrajhar, they have to play this in this patent domain. And as now we got that BTR peace accord signed, and it is a peaceful region, and several promoting for the peace establishment, and industry may also come, and in that time our institution should join hand with the industries, and let's hope for the better future and better patenting future and better IP future from BTR. Thank you.
Thank you so much, sir, for your informative talk on the prospects of IPR with respect to BTR. Now it is open for interaction. Any query can be put forth for answering. Any question? No question. I think everybody has understood, and the crowd has become less. I think they have all exited for lunch. Yeah. Sir, there was a slide where you have written some ordinary application in terms of state-wise pattern statistics. So I didn't get that. Like, what is ordinary application? Like, is it in terms of how much of broth that has been taken in the past?
Yeah, I understood. Her question is in that slide, state-wise distribution, there is a slide that is called ordinary application. The ordinary application is nothing, but when you file in India, there are several types of patent applications. There are ordinary application, that may be PCT national phase application, that may be divisional application, that may be patent of addition. Okay, in that way, when you file your patent, full patent in India, first time, that will be ordinary patent application. Okay, that is nothing about ordinary means it is ordinary and something is premier. Not like that. Ordinary means when you file a full patent, complete patent in India, that will be your ordinary patent.
Thank you. Any more queries? Okay, I think there is no more query. So we are moving on to the final speaker of our invited talks session. He is Mr. Aditya Mittal, Patent Associate from LS Davar and Co. So, right after this, we will move on to the panel discussion.
Good afternoon, everyone. At the very outset, I don't know how much time I am left with, but Sharmishna ma'am, in case I exceed the time limit, you just give me a ping, I will wrap up in 2 minutes. So, good morning and good afternoon, sorry, everyone. I am Aditya Mittal and I work as a patent associate at my law firm, which is LS Davar & Co. Today, my topic would be patent filing and grant procedure in India. Some of the points of which are covered by the prestigious earlier 3 speakers. And I won't bore you much, and I'll cover the remaining points. To introduce, I would be speaking about my law firm for a few minutes and then proceed on with my topic. The point here is to connect with the university and the people of the land. Like if they want any help related to IP advisory or IP filing, they can approach our law firm. So starting with I'm proud to say that we are one of the first law firms in the country. We were started in 1932 by our late founder, Mr. L.S. Davar. Since then, we have been assisting various Fortune 500 companies and other mid-sized companies when it comes to IP protection in our country. Next, please. I basically at LS Davar is associated with their patents team. I am involved in patent prosecution, patent drafting, patent searching, as well as I am involved in Delhi High Court's litigation. I am an Indian patent agent and as well as I am an advocate eligible to practice in various courts of India. So what concerns basically we find between different stakeholders in the IP field, especially when it comes to the law side between the attorneys and the clients, we find these particular issues. First is reliability and trust. And as we have been in this profession, in this field since the last 90 years, I can say that we have clients that have been associated with us since decades. And this shows our reliability and trust. To cut it short, the other 3 points would emerge from the first point itself. This shows that we have the IP expertise, we do detailed amount of work, we know the nuances of the Indian IP offices, which is the reason why we have long-lasting relationships with our clients. And the other point of concern for various stakeholders, especially the small companies, the universities, is the pricing. What is the practice involved in the law firms in the country as well as abroad is they charge on the basis of billable hours. They charge in accordance with the hours which has been taken to complete the work, which basically keeps the client in dark. He doesn't know about the bill that will be formed after the completion of the work. So we at LS Davar has a very transparent policy regarding it. We disclose the prices to the client at the outset and upfront so that he knows what will be the cost at the end of the work. No matter how much time it takes us to complete the work, the cost of the client will remain the same. Next, please. So these are the services with regard to IP which we provide, and basically it covers all the IP related aspects. Next slide. This is a demographic representation of the clients that we represent. We are very proud that to say that we have more than 2,000 US clients, 3,500 European clients, as well as many thousand clients across the world, which shows our reliability and our presence throughout the world. Next, please. This is a list or a representation of the South Asian countries where we have our trusted associates which help us in filing of the applications, and we are deeply connected in these countries also. Next, please. This shows our the domains of the companies that are associated with us, and which shows that we are quite multidisciplinary when it comes to our clients. Next, please. This is why you all can connect with us. It basically lists down the advantages. Main is the pricing, the capability. We have over 100 attorneys present in the country. We have the experience, 90 years of experience in this, and we have advanced IT systems with us, which will help us in the filing process. Next, please. Now, the next 3 to 4 slides will cover the recent awards which we have got in the past 3 years, which involves the prestigious Forbes Award and the Asia IP Award and various other organization awards. Next, please. Next. Next. So this slide shows the association with which we have with these esteemed institutions also. Next, please. The key stakeholders at the firm include our co-founder, Mr. L.S. Davar. He was also a member of the bill which was presented in the parliament back in 1965. The bill which the committee which was constituted to present the report to the Patents Bill of 1965. He was a member of that. So we are involved in the patent making policy since the very beginning in the country. We have our current managing partner, which is Dr. Mrs. Joshida Davar Kimani, who also has been a recipient of many IP related awards. And our late chairman, Mr. G.S. Davar, who recently passed out, he was also an electrical engineer from UK. Next, please. These are our concerned offices in Delhi, Bangalore, and Kolkata. We are soon opening offices in Mumbai as well as Guwahati. Next, please. Now, coming on to the topic for today, I would be dealing with the procedure of patent filing as well as grant in India. Some of the points are already covered. I will not be reiterating the points and will only say the points which are new. So, please, next. Now, what are patents? As rightly said by the speakers, patents is a type of intangible property. Tangible properties have been in our society since time immemorial. So, since the last 10,000 years ago, when human beings started to live in communities, we had this concept of this is your land, this was my land, this is your house. But the concept of intangible properties, I must say, is quite new. It all started around maybe 250 to 300 years ago in the Western countries, where the inventors, the creators were quite afraid to bring out their inventions, their creations, their works out in the public. They were quite afraid that they might get stolen or they might not be properly compensated for their work and their hard work. So this led to the creation of the laws of the associations with protection of the intangible property rights. And nowadays, the intangible property, the value or valuation of intangible property has greatly crossed over the ones of the tangible ones. So importance, as has already said by the previous speakers, it protects your work. It is basically a quid pro quo between the inventor and the society at large. Inventor, he gets some monopolization of the invention, where he can monopolize the invention for some few years, and society can benefit from the invention. Next, it's the statutory right. Now, rights can take form in various ways. We have our fundamental rights, being Indian citizens, which derive from the constitution of a country. We have some rights under the tort law, which comes to us by being India being the virtue of a common law country. Now, this is a statutory right. Statutory right is the right which comes from a particular statute, which in this case is the Indian Patents Act. So it can be a central government legislation, it can be a state government legislation, and the government of the land at that particular period has the rights to change or modify according to the needs. So in the Indian Patent Act is a central government legislation and it came out in 1970. Further amendments took place in the year 2005 and so on. Further, these rights can be of two types, positive as well as negative right. Positive right, to give you an example, can be like if you enter in a contract with another party, the third party has a positive obligation towards you to fulfill that particular contract, or you have a right that the rights which you have got in the particular contract is to be fulfilled by the other person, failing to which you can approach the courts. So this is a type of positive right. Negative rights are the ones which abstain someone from doing something. Like in the case of patents, you are abstaining a third party to catch hold of your patent or use your patent. So this is the reason it's a negative right. Coming on to the circle B now, which states the rights of patentee. Basically, what a property, if I say this bottle is my property, what does it mean? It means nothing if there is no right with regard to it given to me. Basically, a property means you have been given a bundle of rights, like a broomstick, a bundle of rights which have been given to you, and certain things which you cannot do with this property. Like I cannot hit someone with this property saying that it's my property. So what are the rights of a patentee? It gets covered under section 48 of our Indian Patent Act, which says that you have the right, okay, you've got a patent and now you have the right to exclude any third party from, let's say, selling, making, or importing the particular product or the method in India. Next, it's a territorial right. The rights which you get as a patentee happens to be only in the country which has given you the rights. It is to be kept in mind while the patent application is examined in the patent office. The examiner tests the anticipated prior arts throughout the world. So this is the reason nowadays we have PCT filing done, which allows you to choose a particular patent office and you can designate all the countries where you wish to proceed with your patents. So you don't have to every time hop in a different country for protection of the patent. As already said, it's not a perpetual right. It's only given for a period of 20 years from the date of priority. Circle C has been largely covered by the previous speakers. Just to give you a brief overview, I must admit that there are books written on these concepts. Just to give you a brief overview, the Indian Patent Act says that not everything under the sun can be patented. There are sections like Section 3 and Section 4, as rightly pointed out by the previous speaker, which says that certain inventions can't be patented. Like you can't patent anything which is frivolous or which is contrary to the well-established national laws of the country. Or there is Section 3K, which says that you can't just patent a computer program per se or a mathematical program. And now, what does the patent office or the patent examiner sees while testing application for a patentability? As pointed out earlier, it checks for only three things, which is the novelty, the inventive step, and the industrial capability of your application. Novelty in very short terms means that your application should be novel, like it shouldn't be anticipated by any prior publication. There are sections in the Indian Patent Act like Section 29 to Section 34, which states when your application cannot be said to be anticipated, and accordingly the patent office proceeds. To cut it short, it basically means that it should be new and novel. Next is the inventive step. When you disclose your patent application to the public, basically in the background area, you need to mention what are the related area of field, what are the nearest prior arts which have been associated in the field, and what is the inventive step which your application is solving. Like what were the problems with the prior applications and how your application is solving it. So the controller or the examiner sees whether there is any technical advancement with regard to the nearest cited prior art and accordingly decides your application with regard to the inventive step. Next is the industrial application, which means that your application shouldn't be a one-off application, it should be capable of industrial reproduction. This relates to the basic motto of the Patent Act, which is the quid pro quo, that the society at large should benefit from patent and it should be capable of reproducing. Next, please. Now, with regard to the filing of patent application, where to file? Now, our country has 4 patent offices in Delhi, Kolkata, Chennai, and Mumbai, and based on the jurisdiction, each city or each area of India has been assigned a particular patent office. So, accordingly, you can file in the office which is associated. And to check what is the area of the patent office which is associated with your application, there under section 20 of the CPC Civil Procedure Code, we have certain things which need to be checked, whether your residence is in that place, whether your place of business is in that place, and certain more things based on the section 20 and the various court judgments which have come out. So I will not be delving in them. And coming to the next, who can file? Now this is disclosed by section 6 of the Patent Act, which says that either the true or the first inventor can file for an application, or any assignee which the true and the first inventor has assigned his application to, he can file, or any such legal heir of the deceased person who, when alive, was in a capacity to file the application. So these 3 things are given by section 6 of our Patent Act. How to file? Now, before 2007, there were only physical filings which needed to be done. Like you needed to go to the concerned patent office and file the application physically. After which, the government introduced the concept of online filing, and basically the government is encouraging online filing. The rates of online filing of on an application is relatively quite cheaper than the physical filing. Next, please. Coming on to the parts of a patent document, it is basically a techno-legal document consisting of both legal information and technical information. Legal information would include the names of the applicant, the inventors, the details of foreign filings, the power of authority which the applicant has given to some patent attorney, and the technical information would include all the technical information or scientific information involved with the patent, like the drawings involved, the detailed description, the background of the invention, the cited prior arts, and all these things. Next, please. Now, going on to the steps involved in the filing. Basically, when an inventor comes to us that, look, I have something in mind and I wish to proceed with the filing of the application, first thing that we recommend him or her is to do a prior art search. In the prior art search, we basically look out for any nearest prior art with the related technology of the applicant, based on which we submit the report to the applicant, and accordingly he can decide whether to proceed with the application or not, or whether he needs some kind of molding with his application. And after which he finds that now it's the stage, now it would be beneficial for me to file an application and it has got some higher chance of grant. So this helps in it, and it's one of the most initial process of patent filing. Next is there are 30 forms available on the patent office website, based on which we need to communicate with the patent office. For filing the application, first we need to file a form 1, which is basically a application for grant of a patent application, which includes all the details of an application, the number of pages it consists of, the number of claims we have, the number of drawings, the amount of fee that we have paid to the patent office, the signature of the applicants, the inventors, the assignment which the applicants have done towards the inventors have done towards the application, and all the details of the application. Next comes the Form 2, which consists either of a provisional application or a complete specification. If the difference between a provisional and a complete specification is like when an inventor approaches us and says that, look, I have these things in mind, and based on your prior art research, I want to file it. But he's not in a final stage. Like he hasn't come out with the invention as a whole, and just based on the available technology he has, and he wants to secure a priority date. So in that case, we file a provisional application, and after 12 months of filing a provisional application, a complete specification needs to get filed. Now, the difference between a provisional and a complete specification is the complete specification involves everything in great detail, and the provisional application doesn't consist of the claims which the which consist of the boundary of a patent application. Like while drafting a complete specification, it starts with the title of the invention. What is the title? It has to be limited to 15 words. Next comes the field of the invention. What field your invention is concerned with? Whether it is of biotechnology, whether it is of computers, you need to mention the field. Next comes, as I said, the background check of the invention. The background consists of all the prior arts which you find that are quite similar to our invention or the application, and you need to mention what are the technical advantages that your application has, which the background information or the cited prior arts doesn't have. So this helps the controller in finalizing the inventive step objection. Next comes the, you have to give a brief summary of your invention in the application. After which you need to specify the names of your drawings. The drawings are otherwise come in a separate set of sheets with reference numerals duly marked in it, which you need to mark in the detailed description, which helps to delineate the invention in a clean and precise way to the general public as well as to the patent office. Finally, we will have the claims of our application, which is the most important thing of a complete specification. It defines the boundary of your invention, and in case of any future infringement of your application, the court checks for what is your boundary by looking at your claims only. So the claims is the most important and has to be drafted very diligently. The point to be kept in mind while drafting claims is that everything you claim has to be marked in the complete specification. You can't just simply claim anything which is not disclosed in the complete specification. Whatever thing that is claimed has to be delineated properly in the complete specification, which is the key here. Next is we need to file the Form 3, which is the details of foreign filings. As I said that while examining your patent application, the controller has to check for patents worldwide. Now, look for it like there are so many patents available, so many research papers out there. It's very difficult for a patent examiner to look for everything relevant. This is the reason even when if your patent is granted in India, it is not presumed to be valid. Like anyone can approach the court and say, look, I have this application and this should be revoked, or this is the post-grant opposition. So what basically Form 3 does is to help a patent examiner. He might look at the going on foreign prosecutions of the particular application and accordingly take help, like US cited these prior arts, so I can also take help of these prior arts. These prior arts seem to be relevant. Or Europe, this thing is happening, this opposition has happened, so look, I can also cite these references in my objections. So this is what the motto of Form 3 is. Next is Form 5, which is the declaration of inventorship, where the inventor says that this is my invention, I have invented it, and if the inventors have further assigned their application to any further applicant, this also needs to be disclosed. Form 26 is the GPA, which needs to be filed by the applicant to a certain patent attorney, and it is a crucial step in the patent filing process. Once your application is filed at the patent office. After 18 months from the date of priority, you need to file an application for the publication, a form for a publication, and this is the first time when the general masses, the general public, get the crux of what the invention is. And this is the reason when in future your infringement happens of your patent, your rights to monetize your patent or the monetary benefits which you get because of the infringement starts from the day when your application was published, because this is the first time your application came to the public eye. There is a form 9 which says that if you want to publish your application early, you can file it by paying a certain fee, and your patent application would be filed within 1 month from the date of filing the particular form. Next is, after publishment of your patent application, there can be a pre-grant opposition, the grounds of which are duly mentioned in section 25(1) of the Patent Act, and because of shortage of time, I would not be going into the grounds of opposition filing. And here also any person can file a pre-grant opposition. The basic difference between a pre-grant and a post-grant opposition is pre-grant can be filed by anyone, while post-grant can be filed by only any person interested. The reason being the same as of that of Form 3. Any person can file, so that it basically helps the examiner, while because keep in mind your application is still in the examination process. So if other person also files a pre-grant opposition, the controller will get a help as to what the other person is opposing and whether I can also take the particular grounds in my examination report. Next, within 48 months, after 48 months from the date of priority, you need to file a Form 18, which is the request for examination. You request the patent office by paying a certain amount of fee that please examine my patent application, based on which the controller comes out with the first examination report, which has to be replied within 6 months of the coming out of the report. Subsequent to the FER first examination report, the controller can also come out with a second examination report, and you need to answer it within 6 months. It can be extended by 3 months by paying a certain amount of fee also. And if the controller gets satisfied, like the controller basically objects for the similar objections, like your invention is not inventive, it is not novel, it is, see, look, your application is a computer program and it is not patentable under section 3K. Look, this is the nearest cited prior art and this is anticipating your invention. So basically what we do is we make a reply to such objections. And if the controller gets satisfied with our reply, he can proceed with the grant of the application. On rejecting your application, first he has to give you opportunity of being heard. A hearing notice has to be given by the controller before rejecting your application. This comes in line with the principles of natural justice where we have in law that you can't just make a decision without listening to the other party. Next, once the controller gets satisfied or not satisfied after the hearing, he can proceed with the grant or rejection of your application. Granting your application would be done after notification in the patent journal, and a certain patent renewal fee has to be paid by you every year. Following which, after your publishment in the patent journal, any person interested can file for a post-grant opposition within 12 months from the date of grant and oppose your patent application, the grounds of which are mentioned in section 25(2) of the Indian Patent Act, and most of the grounds are same as of that of pre-grant opposition. Still, after 12 months, as I said, your patent application, even if it is granted, if it's not presumed to be valid, anyone can approach the court for a revocation with a revocation petition of your patent application, the grounds of which are given under section 64 of the Patent Act. And once all these things are done or not done, based on the situation, the application is granted up to 20 years from the date of priority, after which it comes out in the public domain. So This was basically a very brief crux of the whole process. And if you have any doubts, you can. I will be happy to answer them. Next, please.
Thank you, Mr. Aditya Mittal. Thank you, Mr. Aditya Mittal. So he gave a very nice presentation on the technical aspect of patent filing, etc. So any queries in this regard is welcome.
My name is Professor Sandeep Das. I am working in the department of tech. So actually, 2-3 months ago, we got a short-term patent. Like when you classify patent, like provisional patent, short-term patent, patents. So we applied in German patent office, patent and trademark office, and we got that patent, the utility model form of patent, on November, and it got published in the patent gazette on 1st of December. Yeah, yeah. Now the issue is whether, because filing a utility model type of patent is a bit different from the conventional patent, where examination and this part will be done late when somebody is objecting to it. So, because this is a new concept and we are finding it difficult to get people understand that utility model kind of a patent and patent short term, long term, and they have even different nomenclatures in different countries, right? In Indonesia, they are being called as PT patents, 8 years. So, can you please explain that to the audience? What is the terminologies, how it differs, so that it becomes easier for others also to understand?
Basically, the concept of utility patents and short-term patents, which you are mentioning, are currently not available in the country. There have been discussions and there are going on discussions in which our law firm is also a part between the different stakeholders. But you cannot apply for a utility patent in India. What you can do is apply for a patent, not also for a shorter period. You have to apply for the whole process only, the 20 years period. But there have been advantages which various stakeholders are regularly giving out to the government of utility patents, which are there in the US and other developed countries. So let's see what the government thinks.
In US, in Germany, and in Australia, they have stopped in 2021. But then these are still applicable in Germany, and these are basically used for academic purposes. Once, suppose there is a kind of a opposition, or then it goes for scrutiny. I mean, the whole process is reversed there. So in India, it is of now we don't get, but then in Japan, in China, in Germany, it is prevalent, right? So just for a knowledge for the audience, I guess, because many of us we don't know what is a short-term patent, what is a utility model, what is a provisional patent.
Look, I can comment on it, but as I am concerned with the practice in India, I think I would not be the right person to comment on the prevalent practices which are involved in other countries.
Sir, I'm working for various international patent. We have filed, we have got it. But previous speaker and former examiner also mentioned about the patent is a territorial right and rightly covered by this speaker. That is with respect to the India, and there is no short-term patent. However, people particularly, unfortunately, maybe I don't know whether I should say unknowingly or whatever manner, but maybe in hurry, they apply, they get the patent, but that's not an use. We have certain system called, rightly mentioned by our previous speaker also, PCT, and we are also member of Paris Convention. So what we do in our firm practices, particularly get the patent in India, within 12 months take the PCT route, and then to the international patent system, and then to the designating office. So RO receiving office to the designating office. That's a journey what we have. But for sake of credit, people are now filing an application in other countries, maybe in Australia and other countries. I've seen that from very close. That sake of that we have an international patent, and just for purpose, that's not an international patent. There is no concept called as an international patent. Patent is a territorial right. Yes, there is a treaty which is proposed called PLT, but India is not a member of PLT. India is a member of PCT. India is a member of Paris Convention. But mainly we found in academics, for sake of credit, people are applying for various countries, but there is no use, unfortunately. It's a waste of money. However, that's in India. We can go to the Indian Patent Office, and now mentioned by previous speaker, within 5 to 7, I have a record of 5.5 month patent granted. So that way we have very speedy, and mentioned by the previous speaker, there is a provision for the examination under section 18 and 9. 9, you have an early publication, you can immediately within 2 weeks it will be published. And there is a provision under section 11. From the date of publication, it is consumed, particularly it is you can start commercialization. Then why we are going and spending our money and foreign exchange to the other country? So instead of that, particularly we have a publication, section 9, we have an examination. Further, in academic, they have reduced the fee drastically. 90% reduction fee is there for the academic application. And then further, government, I mean Maharashtra, they have a provision of financial supports for the inventor. Then also they have a support for the academic institutes and professors. Further, actually, there is an expedite provision. You can expedite it. So you need not to be in an ordinary queue. So those are facility fortunately made available by the Indian Patent Office for our inventor. Unfortunate data, even see the day before yesterday's news published by the USTR, where they say India at 44th ranked out of 55, and everyone is writing about that. India is lagging behind on patent filing and intellectual property filing and all of. However, we are filing in somewhere else. Being a nationalist, being an Indian, I think we should give the preference to the India. And there you can utilize your industry. So one patent is equal to one industry, and you can create an employment for your people. So my humble submission would be, do not fall into the trap where people are mentioning about the foreign application, international patent application and credits. That is not credit. I have advised to the many institute, including NAC and all. I've been to West. So that will not be considered, rather that will be a boomerang to you in future. So yes, if you find there is a great opportunity to you in Australia, like what we did it for the solar panel cleaning system. Adani established their industry over there. They are in a bad need of such kind of technology, and I work for this gentleman, and immediately we took it within 5 months to there, and then what you said, sir, rightly about the short-term patent and all. There you have an advantage. So I humbly request this for this artist gathering, particularly. Yes, let's benefit to our India. Let's benefit to this and stop these people, US people saying, "Oh, you are at 45th and rank and all." We should be among top 5 in India finally, and in properly from our own people to for our own people. Sorry if I exceeded my limit. Thanks.
Actually, thank you, sir, for your that insight. Actually, I would like to add into this some of the law firms. Actually, nowadays, what they are doing, they have found that some academic importance are being given to the professors and other academic institutions for their upgradation and all these things. So they are circulating the bulk mail to the professors, saying that this is the Australian innovation patent or Germany the utility model. This will be granted in 6 months or 3 months like that without examination, and it will be same value in your CV and all these things. So due to that promotion, actually they are going into I will say it a kind of trap, and filing that and getting granted in 3 months without any examination and all, getting that certificate and getting that API score and all. So this is
Thank you to all the speakers. With this, we have come to the end of the first session of today, that is invited talk. Now we shall proceed towards the panel discussion, which we have swept with the 2 p.m. slot. And the paper presentation shall be conducted from the 2 p.m. slot. So now I would like to request the invited panelists to come and take your seat on the dais. Professor Narendra Lokkar sir, he is the first panelist. So please take your seat on the dais. He is Professor Narendra Lokkar, retired professor from Guwahati University. He has been working immensely for the popularization and awareness of intellectual property rights in this region. I would like to request our students to please come up and felicitate him with the traditional Aranai. Thank you, sir. Next, I would like to invite on the dais the second panelist of today's panel discussion, Professor Ganesh Hingmire, sir. He had been already the first speaker of today's invited talk session. I would like to request our students to please come and felicitate with an Aranai. Thank you, sir. We have a special invitee today, and I would like to welcome him also onto the dais. He is Commodore Rajiv Ashok, the MD of Neramek Guwahati. We are so glad to have him amongst us. He is a special invitee today because Neramek has been the knowledge partner with the IPR team of Bodoland International Knowledge Fest. We welcome him, and I would like to request our students to please felicitate him with an Aranai. Commodore Rajiv Ashok sir shall be presenting a special presentation of his organization today at the end of the panel discussion. Thank you, sir. Thank you to all our invitees. Now moving on to the panel discussion. The topic of our panel discussion today is IP in the protection of indigenous knowledge and entrepreneurship development. So we have learned a lot about the utility of IPR, the significance of IPR, especially with reference to the academia, and also the BTR. Traditional knowledge, which is considered as a living body of knowledge that is developed, sustained, and passed on from generation to generation within a community, often forming part of its cultural or spiritual identity. And because such knowledge has ancient roots and is often informal and oral, becomes very difficult to be protected by the conventional IP. Besides the necessity of providing legal protection, traditional knowledge also requires proper documentation for its protection. So with this, we can move on to our panel discussion today. And for this, I would like to request one of our panelists, Professor Narendra Lokkar,